Good morning. For those of you who don't know me, I'm Judge A.N. Jappi. I was the Judge President of the KwaZulu-Natal High Court. I have since retired. I think I was last in court more than a year or so ago. And I've been asked to step into the shoes, so to speak, of Justice Brunt, and that was in July last year. And I tried to convene this tribunal sometime last year, but we couldn't get together, and this is the date that was agreed upon. I will now let the rest of the tribunal introduce themselves. On my right, Judge Mashidi. You may introduce, this is Judge Mashidi, if I may do that. And this is Attorney, how do I pronounce that full name, please? Yeah. Yes, and that is the tribunal. We are sitting as a tribunal. We've been asked by the JSC to look into the facts of what is going on in this matter, so to speak. And we report back to the JSC. We simply make a recommendation for those who don't understand the proceedings, and it's the JSC who finally makes the decision as to how to go forward from then onwards. The JSC either accept our recommendation or they come up with their own recommendation. The recommendations made by this tribunal, it's only a tribunal, is not binding on the JSC. And we are simply here to look into the facts as to the conduct of Judge Makhubele and to then set out the facts for the JSC, and we make suggestions and the JSC takes the final decision. And that's what it's all about. We have a complaint, and that's what we're investigating, against Judge Makhubele. And that is why we are gathered here today. I will now let the rest of those who are present introduce themselves, starting with Advocate Zungu, whom I do know, and Advocate Paver sitting next to her. They're from the KwaZulu-Natal office of the DPP, but I will start there and then I will go to Judge Makhubele's representatives and then the complainant, who is united behind. Please, Ms. Zungu. Yeah.
Good morning. Thank you, Chairperson. I'm Advocate Elaine Zungu. I'm the evidence leader at this tribunal, and I am being assisted by a colleague who will also introduce himself. Thank you.
Good morning, Chairperson. I'm Dorian Paver, and I am a member, although on pension and retirement, I'm employed by the National Prosecuting Authority and assistant to the evidence leader.
Good morning, Judge Jappi. Good morning, Justice Msidi. And good morning, Ms. Maduba-Silevo. Judge Jappi, we met a long time ago, but in different circumstances. My name is Vincent Maleka. I represent Judge Makhubele, together with my colleague, Mr. Mfundo Salukazana, on instructions of my attorney who is present here.
Thank you, Judge Jappi, members of the tribunal. My name is Michael Bishop. I act for the complainant in this matter, hashtag Unite Behind, and I appear together with Advocate Ntunano Mashava, who unfortunately is not with us today. She has an appearance in the Supreme Court of Appeal, so she apologizes that she's not here. She'll join us from tomorrow, and with Advocate Benjamin Prinsloo.
Thank you all. I think that is really the participants in this tribunal. I am given to understand, and we do have an application by the complainant, as I understand it, to cross-examine witnesses. That's the first thing that we would have to deal with today. Well, is that application proceeding, or what's the situation there? And let's first deal with that, and then we will deal with whatever witnesses the evidence leader wishes to call. We have a list, but it's really up to her. Yes.
Thank you, Judge Chappie. Judge, it's a fairly unusual situation. We have never brought an application before this tribunal. What happened is that we've been participating in this process. My client has been participating in this process throughout, from when it laid the complaint before the Judicial Conduct Committee, before the Judicial Services Commission, in all the pretrial hearings before this tribunal, up until November last year, with the understanding that when it came to this tribunal, just like was the case in the Chlorpe tribunal, my client would be entitled to participate, to the extent necessary, ask questions of witnesses, and make argument at the end of the tribunal. At the pretrial meeting on the 14th of November, the representatives for Judge Makhubele raised a concern about the complainant's standing and questioned whether or not the complainant had locus standi to participate in the proceedings at all, in any way. And so that was the position, and that was the issue, as we understood it, that was then going to be the in limine issue for this tribunal to decide. And so it's not an application to cross-examine, it's a question really about what is the nature of the participation of the complainants, the nature of the rights of the complainants. So I'm happy to argue that first and then let Mr. Maleka respond to that. But that is how the issue arose, as I understand it.
The nature of, it's the nature of the complainant in this tribunal. Is that the issue that you want us to decide?
Yes, Judge Chappie, so if I can say what our position is, what we envisage our participation being. We are subject to the tribunal's directions. The tribunal regulates its own process.
Yes.
My client has worked with the evidence leaders in developing the case, helping them, suggesting which witnesses to consult with, and so we don't see ourselves as another evidence leader. But we do want to participate in the tribunal, and that, in our view, involves two primary issues that we want to do. We want to be able to put questions to witnesses. We don't intend to repeat anything done by the evidence leaders, but my client has both a wealth of experience in the underlying facts. It's been involved in this complaint since 2017. And so there may well be questions that will assist this tribunal in order to perform its duty to get to the truth of the matter, to determine the facts. So, Judge Chappie, it seems to us in an inquisitorial setting such as this, whether that's called cross-examination or not is maybe a bit of a technical term, and within the tribunal's hands, the nature of those questions, but we want to be able to put questions to witnesses. And then at the end of the proceedings, we want to be able to present closing argument based on the evidence that's been laid before this tribunal. We don't anticipate, we don't at the moment intend to lead any of our own witnesses, but we don't want to concede at this stage that it may not arise that we wish to call a witness based on what happens in the tribunal. But that's not our intention. We have no plan to call any witness at this stage. At the moment, we know which witnesses the evidence leaders wish to call, and we don't have any additional witnesses to call. And as we understand the objection from Judge Makhubele, the objection is that because the JSC Act and the rules for judicial conduct tribunals don't expressly provide for the participation of the complainant, therefore the complainant is not permitted to participate, that it would be unlawful for the complainant to participate in that way that I've described. And that really seems to be the issue that's in dispute between the parties, both whether the complainant may participate and then whether, in the discretion of the tribunal, the complainant should participate and what the nature of that participation should be.
Yes.
So Judge Chappie, perhaps I should present my argument on why, in our view, we have a right to participate, but at the very least, this tribunal has the discretion to permit my client to participate. So we submit that there's really three issues that I want to address and three reasons. The first is that there's a general presumption in favor of hearing both sides. Secondly, that properly interpreted, the Judicial Services Commission Act actually supports participation for the complainant, and there's no exclusion of participation in either the Act or the rules. And thirdly, that this issue has already been addressed in the previous Judicial Conduct Tribunal for Judge President Khlope and by the Judicial Services Commission that considered that recommendation, and then by the full bench of the High Court that considered Judge Khlope's review of the participation of the complainant in that tribunal. So if I can deal with the first issue, Judge Japie, which is we said that there's a presumption that unless Audi, the right to be heard, is specifically excluded, that it should always, legislation, rules, regulations should always be read to include that right. And we think it's important to focus on what is Audi and why do we protect Audi. This case isn't in our heads of argument, Judge Japie, but it's something that arose from the responding submissions we received from Judge Makhubele yesterday. It's the well-known case of De Lange versus Smuts, NO. The citation is 1998, Volume 3.
Just before we actually get, you said the first ground is that you think you have a right to cross-examine witnesses. Do I understand? And it's really up to the tribunal to decide whether such a right exists or not. And you are now arguing that although it's not specifically stated in the statute that you may cross-examine, you believe that you have that right at common law, for want of a better word, to cross-examine. Is that how I understand the argument? Or is it something else? Let's just clear that up. What is the position?
Judge, I think at common law, the right is more general. It's a right to participate in the proceedings, and the nature of that participation must depend on the nature of the proceedings. This is a tribunal where witnesses are going to be led in order to adduce facts. And in order for my client to effectively participate in these proceedings, in order to ensure that its complaint is fully adjudicated, that the tribunal, at the end of the day, has all the relevant facts to reach its conclusion, it cannot do that without being able to put questions to witnesses. And so in the context of this tribunal, that's necessary. But obviously, we're not asking Chairperson for an unregulated right to cross-examine at will. We don't want to waste the tribunal's time. We want to assist the tribunal. But we don't believe we can participate effectively without being able to put questions to witnesses and then make argument at the end of the proceedings. Briefly, Judge Japie, if I can just mention, I was going to refer this court to De Lange versus Smuts. So the reference was 1998, Volume 3, South African Law Reports, page 785, and it's a decision of the Constitutional Court at paragraph 131. And it's a concurring judgment of Justice Makhubele, but it's subsequently been endorsed by a full unanimous Constitutional Court. But what she said is, at heart, fair procedure is designed to prevent arbitrariness in the outcome of the decision. The time-honored principle that the other side should be heard aims towards eliminating the prescribed arbitrariness in a way that gives content to the rule of law. It reaches deep down into the adjudicating process, attempting to remove bias and ignorance from it. Everyone has the right to state his or her own case, not because his or her version is right and must be accepted, but because in evaluating the cogency of any argument, the arbiter, still a fallible human being, must be informed about the points of view of both parties in order to stand any real chance of coming up with an objectively justifiable conclusion that is anything more than chance. And that has been endorsed by the Constitutional Court just briefly in the Makhubele case. The reference is 2018-1 SA 1 CC at para 93. And we say that's why there's this presumption. We refer to in the heads, I don't need to take you to the Muhammad case, that says really the question is, the mere fact that legislation does not specifically make provision for hearing does not mean that there's indeed no such right. And the respondent doesn't really dispute that presumption. The argument that they make in their submissions is more that the complainant here doesn't have a right that requires protection, that requires them to participate in these proceedings. We frankly find that a strange argument, because the whole point of Audi is to hear both sides. What we have here is a complaint by my client against Mr. Maleka's client that Judge Makhubele is not fit and proper to hold judicial office for the various reasons this tribunal will investigate. And my client clearly has an interest and a right to ensure that that complaint is fairly adjudicated. But also, my client is seeking to vindicate other rights. The reason why my client Unite Behind laid the complaint in the first place is because it is a coalition of NGOs, of non-governmental organizations, community organizations, that have both a general interest in the rule of law and an independent judiciary, and a specific interest in protecting the rights and interests of commuters. And the reason they became involved in, brought this complaint is because of Judge Makhubele's involvement in PRASA, and the concern that maladministration and corruption in PRASA ultimately affects commuters, and it's their rights that are ultimately undermined by that conduct. And in my client's submission, that includes Judge Makhubele's conduct. And we also submitted a strange argument because throughout the JSC Act, the complainant is given the right to participate. Before the JCC, before the JSC, in an appeal proceeding, if this commission makes a recommendation to the JSC, my client again has a right to participate. And the reason the Act gives that right is precisely because it recognizes that my client has an interest to be heard, and that a rational outcome can only be reached if both sides are heard. So Judge Japie, that then brings me to the Act. And the question based on the Mohammed case which we cite is not where in the Act does it say the complainant may examine witnesses? Where does it say in the Act the complainant may make closing argument? The question is, where in the Act does it say that my client may not? And the answer is nowhere in the Act. There's nothing in the Act, there's nothing in the rules of the Judicial Conduct Tribunal that says the complainant may not participate. To the contrary, we submit that properly interpreted, it's clear that the complainant should be allowed to participate. And we say that for three reasons. The first is, as I've mentioned, it's allowed to participate in every other stage expressly. And so we submit it would be a very strange reading of the Act to say a complainant may participate at every stage before and after the Judicial Conduct Tribunal, but must sit at the Judicial Conduct Tribunal in silence and say nothing. When it really matters, when the evidence is really going to be led, it must just sit as an observer. That would be a very strange reading of the Act, given what it says about the complainant's participation elsewhere. The second reason is that the JSC Act specifically allows for both the complainant and the complainant's legal representatives to be present. And the Section 29(1) of the Act limits quite strictly who may attend a Judicial Conduct Tribunal. It has a list of who may attend: the respondent, the witnesses, and one of them is the complainant, and then in 29(1)(d), the complainant's legal representatives. It's difficult to understand why the complainant's legal representatives would need to be present merely to observe the proceedings and not to participate in the proceedings in a way that would assist the tribunal with its work. The third reason in the Act is, as this tribunal is well aware, Section 25(4) says that subject to this Act, the tribunal has the power to regulate and protect its own proceedings. And that obviously needs to be read with Section 26(2), which says a tribunal conducts its inquiry in an inquisitorial manner, and there is no onus on any person to prove or disprove any fact before a tribunal. And the object of this tribunal in Section 26(1)(a)(1) is to collect evidence. So we submit, at the very least, this tribunal can regulate its own process and can permit the complainant to participate if it believes it will be in the interest of it performing its task, its obligations. And in the absence of any prohibition in the Act or the rules, again, we submit it would be a contorted reading of the Act to prohibit complainant participation. And of course, the Act must be interpreted, as the tribunal members are well aware, in line with Section 39(2) of the Constitution, to promote the spirit, purport, and objects of the Bill of Rights, which includes the right in Section 34 to have any dispute that can be determined by the application of law, determined in a fair and public hearing, by a court or another independent and impartial tribunal. And we submit that the respondents' counter-arguments to this there's two of them. The first is really the exclusio alteris argument, which is, well, because the complainant is given the right expressly before the JCC, the JSC, and the JSC again, and is not given the right expressly before the JCT, therefore you must interpret that as an intention to exclude. But we submit that this is really a misuse of the exclusio alteris principle, and it was dealt with expressly in Muhammad, which is a case about Audi. And what the Justice Ackerman said there at paragraphs 40 to 41, I don't know if the tribunal received the bundle of authorities that we provided, but it is at pages 22 to 23 of that bundle. But I'll read it briefly to the court. What Justice Ackerman said is, although there is no express reference there to in its judgment, the High Court clearly relied implicitly on the interpretative maxim that, quote, the specific inclusion of one implies the exclusion of the other. This maxim has been described as a valuable servant but a dangerous master. It is not a rigid rule of statutory construction. In fact, it has on occasion been referred to as a principle of common sense rather than a rule of construction, and it must at all times be applied with great caution. There are circumstances when the inclusion of a particular provision occurs because of excessive caution, or where the legislature is either ignorant or unmindful of the real state of the law, or for some other reason that does not warrant the inference that its inclusion in one provision means that it was intended to be excluded in the other provision. So we submit that when you look at the Act at the whole, you look at its underlying purposes, the purpose of this tribunal to reach the truth, it would be inconsistent with the purpose of the Act to prohibit complainant participation. The second reason that my learned friend invokes is really a slippery slope argument, which is that under Section 29(1)(e) of the JSC Act, witnesses are allowed to be present, as well as the legal representatives of witnesses. And the argument is, if we are allowed to participate and ask questions of witnesses, then every legal representative of every witness who comes before this tribunal will also have the same rights and be able to participate in the same way. And that will make these tribunals unmanageable. And that's obviously not the argument at all, and it doesn't flow from the Act, because 29(1)(e) sub 2 says that witness and that legal representative may be present only for the period that person is required by the tribunal. Contrast that to the rights of the complainant and its legal representatives, who are entitled to be present throughout the entire tribunal. And the purpose of the legal representative of a witness being present is not to lead evidence about the underlying fact. It's to protect the rights of the witness who's being questioned. So it's an entirely different purpose. The tribunal will regulate its process as it sees fit to prevent any of that.
Then can I put this to you? Just hold it on that point. If the witness doesn't give any evidence that implicate the complainant, does the complainant's representative still insist that they are entitled to question that witness?
Yes, Judge Japie.
Why?
Because, Judge Japie, what we want for this tribunal to do is to get to the truth of the complaint against Judge Makhubele. And my client is a complainant that, as I said at the outset, has been involved in investigating this since 2017, has a wealth of knowledge about what occurred, has a wealth of investigative experience about what occurred, and has an interest in ensuring that this tribunal reaches a fair, legitimate outcome on all the facts. And so we have full faith in the evidence leaders, and we see the evidence leaders as performing the primary role. But we see our job, we see this as akin to an inquest or a commission of inquiry. And in both those instances, you have, in an inquest, you have the prosecutor, but you also have the right of any complainant or person with a direct and substantial interest to participate and put questions to witness. Those commissions ultimately reached legitimate outcomes with all the evidence was fulfilled. Because, Judge Japie, there's a risk that if this tribunal determines my client may not participate, that there may be evidence from witnesses that is not elicited because my client wasn't given the opportunity to put those questions to the witness, and that may ultimately affect the outcome that this tribunal reaches.
But this tribunal convenes and sits to assist the Judicial Conduct Committee. Isn't that so?
My understanding is that it goes straight to the Judicial Services Commission.
Well,
Yes.
but the Conduct Committee,
Yes.
it's to assist that, and it's the JSC who makes the final decision.
Yes, that goes to Parliament.
Whatever decision that comes from here eventually ends up with the JSC, as you correctly pointed out, and they must take it further. We are basically, as I understand it, and please correct me if I'm wrong, we are simply an evidence collecting body for the JSC ultimately, and to make recommendations. The JSC either accepts the recommendations,
Yes.
or they make their own recommendations and they decide to go forward from there. As I understand it, the JSC will hear the complainant before it makes its decision. But the Act doesn't provide, and am I correct, that the Act doesn't provide for the complainant to cross-examine at a tribunal, if we may even call it cross-examination as such. That is the construction of the statute as far as it governs the sitting of this tribunal. You want us to read into the statute, as I understand it, that either generally, and this is what I want to hear, or specifically, the complainant in any matter that comes before a judicial services tribunal such as this is, would have the right to cross-examine witnesses. Is that what you want us to do? Or is it specific to this particular case?
Judge Jeppe, I think the tribunal only needs to decide this case because this tribunal is regulating its own process.
Yes.
So it doesn't need to make a finding, and this tribunal doesn't have precedential effect. It's not sitting as a court. It can only make a finding for this specific tribunal.
Well, that's
So-
where I was going.
Yes.
And it's
Yes, Judge Jeppe.
Nowhere in the statute does that governs the working of this tribunal specifically states that a complainant has a right to cross-examine, if I may put it that way, any witness. That is the way the statute reads. Am I correct?
It doesn't expressly provide for it, but that's why we emphasize the point that the question is, well, what should this tribunal make of that fact?
Yes.
What should it make of the fact that there's no express provision? And that's why we say that at the very least, that doesn't exclude this tribunal, it doesn't prevent this tribunal from determining, in order for it to perform its function, to collect evidence, as you put it, evaluate that evidence, make a recommendation, to be able to do that in the most effective way that it can. Will it be assisted or will it be hindered by permitting the complainant to put questions to witnesses?
Well, the complainant is here simply because it has lodged its complaint.
Yes.
The witnesses are here to see whether there's any merit in the complaint as such. Am I correct? And then we, as the tribunal, find the facts and put it to the JSC, as you pointed out. But there is no proceedings before this tribunal that results in any, how would one put it, a finding that would lead to a prosecution, for example. We can't say that the prosecutor must prosecute.
No,
That's up to the JSC. They can
Yes.
do that. So what purpose would be served if the complainant under this tribunal is given a right to cross-examine witnesses or examine witnesses other than its own witness?
Well, Justice Jeppe, the the point would be to make sure that all the relevant evidence
Yes.
is elicited. The point of putting questions to a witness is to obtain evidence from that
Yes.
witness. And if certain questions are not put to witnesses, then that evidence may not come out. And we don't want to, we're not going to repeat questions by the evidence leaders, we're not going to waste this tribunal's time. But if there are questions that are not put to a witness by the evidence leaders, that we know from our knowledge of the documents, our client's knowledge of the history, would elicit from that witness evidence relevant for this tribunal to do its job. That should, in the words of the JSC, be welcomed and encouraged. Because this is not the first time this has come up, Judge Japie. It came up in the Hlophe Tribunal. And
Yes, I can understand. Let me just, my
Yes.
understanding of the Hlophe Tribunal.
yes,
I don't know if the Hlophe Tribunal is really persuasive here because we haven't heard any evidence. But before the Hlophe Tribunal, there, Judge Hlophe directly implicated the complainants. Isn't that so?
it is so, but that wasn't what their participation was
No.
limited to.
No,
They cross-examined on their complaint against him.
Yes.
They didn't only participate in the allegations against the justices.
I understand that. The question really is, well, once you're given the right to ask questions, then it's get controlled by the tribunal as such.
Yes.
But there, Judge Hlophe directly implicated the complainants. Isn't that so?
It is so.
Yes.
But that's not the basis on which they participated.
Yes,
And if one looks at what the JSC said about this, it said their participation contributed to the proper administration of justice in the matter, and that such participation is to be welcomed and encouraged in future cases. Because
Yes.
it contributes to the administration of justice, which is this tribunal's task.
Yes.
And this tribunal can regulate its own process. The JSC saw nothing wrong with the complainants in that matter participating. And Judge President Hlophe complained about it to the High Court, and the High Court saw nothing wrong with it. The High Court rejected that as a ground of review. So, Judge Japie, I accept that the High Court judgment is not precedent that this court must allow it, but it is good precedent for that it may allow it, and that there's nothing irregular if this tribunal, sorry, not this court, this tribunal permits the complainants to participate. And there's nothing in the JCT ruling on this, in the JC comments, that links participation to the adverse statements that were made by Judge Hlophe against the complainants. And of course, by that stage, that complaint had been dismissed, and the SCA had upheld the dismissal of the formal complaint against the Constitutional Court judges.
Well, why can't we proceed then on this basis? The evidence leaders will call their witnesses, and we will take it witness by witness, rather than for this tribunal to just declare that you would just have a right to put any questions to every witness that is called. You may say that you don't wish to cross-examine or examine any specific witnesses, just witnesses that you think that the evidence leader had not fully dealt with. Is that the position?
We would be very happy with that, Judge
Well-
Japie. I mean, my only concern would be that I wouldn't want to have a long debate each time about
Yes.
whether or not we should
No.
be entitled to. But I can give you this assurance, Judge Japie. We do not intend to, we will only put very relevant questions that have not been put by the evidence leaders. That's our intention.
Well-
And this tribunal will always be able to control our participation and say, you're now veering off stream, this is repetitive, this is irrelevant, please stop.
Then why don't we, subject to anything which comes from the complainant, Advocate Maleka, we deal with it on a witness-by-witness basis. The witness will give evidence. You're entitled to sit in. The counsel or the evidence leader will lead the evidence. If you think there's anything that should be brought out, is to let the tribunal have the issue. And we will then deal with it, whether the complainant should put questions to witnesses dealing with what the evidence leader had failed to do. I will not, speaking for myself, for the moment, allow cross-examination generally. You know, cross-examination can go on for days.
Yes.
That will not happen over here. You will, as I said, deal with it on a witness-to-witness basis, and you would inform the tribunal more or less the areas you want to examine, and we will deal with it on that basis. I'm not saying that that is the ruling of the tribunal.
Yes. On
On your argument, on what you've put to us, would that not be sufficient to meet your concern? You may take instructions or here.
Judge Jeppe, yes, I think that would meet. And we've called it cross-examination, but just because there isn't another word, this is a different type of tribunal. We want to put questions to the witnesses, and we would be satisfied with that approach.
So this is then the...
Sorry, Judge Jeppe, just...
Yeah,
and
sure.
we also want the right to make closing argument at the end of the tribunal.
Well, yeah, that's another issue.
Yes.
The tribunal that I have been involved in, I allowed the complainant to address the tribunal. That's a separate issue
Yes.
altogether. I want to know how we deal with the witnesses.
Yes.
And if we deal with the witnesses, and I'm suggesting to you, on a witness-by-witness basis, rather than a general right to cross-examine, what do you say to that? And as I understand it, you'd be happy with
We'd
that.
be happy with that, Judge.
Yes. So the application basically is if there's anything that you feel, and I put it as broadly as that, not necessarily implicate your client or whatever, you would let the tribunal know what it is that you want to elicit, and the tribunal will then rule whether you may pursue that issue with the witness.
Yes,
Is-
Judge.
is- But as far as the proceedings are concerned, the evidence leader will call the evidence.
Yes.
Those representing the judge will cross-examine, because they've always had that right.
Absolutely.
And if there's anything left out by the evidence leader, this is how we will proceed for the moment, and I will discuss it with my colleagues, is you will first talk to the evidence leader and say,
Yes.
these are the issues that, and they will then say, no, we don't want to take it, and you say there are issues which they don't want to raise, we would like to raise, and you will tell the tribunal, and we will then decide whether you may put the questions. That's for the moment is only my view. The tribunal may come to another issue altogether.
Yes.
Yes.
Judge Jeppe, we'd be satisfied, and as I understand, the evidence leaders would lead the witness. We would then inform the tribunal we wish to address these other issues. The tribunal would make a decision. If it says yes, we would put those questions, and then Judge Makhubele's lawyers would be entitled to cross-examine after we had, so that they would be able to cross-examine on... It seems
Well-
as that would be fairer to Judge Makhubele.
It seems
cross-examine
fairer
afterwards.
to the judge
Yes.
that when all the evidence is in, they can cross-examine
Yes.
on whatever it is.
Can I ask you?
Yeah, sure.
Can I ask you if there's anything in the legislation before us connected with this matter that prevents you from conferring with the evidence leader?
No, Judge Mashidi, and my client has been conferring with the evidence leaders in the preparation for this. And I accept Judge Jaffi's suggestion, which is that we should put to the evidence leaders, we think these are important issues you should canvass with the witness. But there may be a disagreement between us and the evidence leaders, or it may be omitted accidentally or for whatever reason, and we think there's a very, very important document we need to put to this witness that may not be put in cross-examination. There's a lot of paper, it may not have come to the tribunal's attention, and we think it's important that this is put to this witness. And then we would like the opportunity to do it. So, because the evidence leaders are here, they have their own mandate. They may not agree with the complainants about every aspect of this case.
The arrangement proposed to you by the chairperson now, is it acceptable to you that it should be reviewed from time to time? At least let's
Yes.
just start it with this the meat of the matter. Matter's been coming a long way,
Yes.
but is it acceptable to you and your clients if this arrangement is reviewed from time to time, as and when the need arises?
Yes, Judge Mshidi, we hope that we'll demonstrate in our questions that we are here to assist the tribunal and not hinder its work. And so we hope we can be of assistance. But the tribunal always must regulate its own process. It must determine the matter fully but expeditiously, and it must decide how best to do that. No, thank you very much, Chairperson.
Before we hear you, I'd like to hear from Advocate Maleka.
Justice Japie, I will take instructions on the midpoint you proposed to the complainant. And
I'd like to take instructions now.
before I do, I'd like to make 3 observations
Yes,
around
certainly.
the debate that you have had.
Yes.
And if the debate arises again, may I place on record that my learned friend, Mr. Salukazana, has heavily prepared on this issue. And if it becomes necessary to address you again, with your leave, I'll ask him to present the address on behalf of Judge Makhubele. The 3 points I'd like to make before I take instructions are these. This is your inquiry, established under a specific statutory provisions. For the present purposes, I ask you to consider Section 26, subsection 2 of the JSC Act, usefully captured in the booklets before you. In its terms, it provides the following. A tribunal conducts its inquiry in an inquisitorial manner, and there is no onus on any person to prove or disprove any fact before a tribunal. We make 2 points in that regard. It is your inquiry. It is not the complainant's inquiry. They have no common or statutory right of the kind they suggested in the opening oral arguments presented to you. You are entitled to give any guidance and direction in running this inquiry. So we differ fundamentally with our learned friends when they suggest to you that you must read the Act by incorporating and implying a right of participation of the kind they assert. It's not there in the Act. First observation I'd like to make. The second observation I'd like to make relates to Section 27 of the self-same Act. And I'll read the opening parts of it, leave the rest to you to consider should it become necessary. And the preamble to it reads thus: in the interest of protecting and enhancing the dignity and effectiveness of the judiciary and the courts, a tribunal must, and it mentions matters that the tribunal must consider. But the fundamental point I'd like to make is, as you conduct this inquiry, the guiding principles are that you do so in order to protect and promote the effectiveness and the dignity of the judiciary, including the very judge before you. I make that point because one must be careful to allow a participation by a complainant fundamentally based on the suggestion that the complainant knows more about this case than the former prosecutor. I make that observation on the basis that the complainant believes that there is an issue between it and the judge concerned. There is not that kind of an issue before you, as between the judge and the complainant. So that it is important to always bear in mind that guiding principle, because it would be rather odd that at the end of the inquiry, you may make a finding that vindicates the judge consent. But the process behind that finding is littered with all manner of concerns and illegitimacies. And we would submit that as a matter of process, the principle must be captured to protect the integrity of the judge and his or her dignity. After all, she still is a judge until you make that finding. She, like any other judge, deserves the recognition of her dignity. And on that basis, we would ask you to regulate a right which the complainant asserts. They have no right of the kind they suggest. On that score, I would ask for your permission to take instruction from Judge Makhubele to see whether or not she will take guidance from the midway point you have suggested. I think 5 to 10 minutes. Let me say 10 minutes at the outside, because I always get it wrong when estimations are at issue.
I'll tell you, let's take 15 minutes.
Thank you, Judge Japie.
Yes. We will then stand adjourned, and I'll wait for Advocate Maleka to call us again. Thank you. We back on record. Advocate Maleka.
Thank you, Judge Chappie. And once again, thank you for the indulgence. We have spoken to Judge Makhubele, and she agrees that the guidance you have provided is the one on which we should proceed. And therefore, we will take it on a case-by-case basis.
Thank you. Advocate Zungu, do you wish to add anything?
Thank you, Chair. There's no submissions from myself, and I agree with the proposal that has been put by yourself as the chairperson. Obviously, everything will be dealt with as and when it comes and arises during the tribunal hearing. Thank you, Judge.
No, just to thank Judge Makhubele and the tribunal for reaching an accommodation.
Yes. Thank you. Then, in regard to the point in limine raised by counsel for the complainant, we will proceed then on the basis that we'll take it a witness at a time, and we will then decide whether we should allow the complainant to put through the legal representative any questions to such a witness. Otherwise, the normal procedure as envisaged in the Act would apply. The evidence leader would lead the evidence. Counsel for Judge Makhubele would put questions. And that is how we will proceed. And if there is an application to put further questions, counsel who appears for the complainant will consult with the evidence leader, and the evidence leader would either agree with what is being requested, or if not, if there is a disagreement, the parties will inform the tribunal, and we will then take a decision whether we should allow any questions from the complainant to be put to the particular witness. But there is no The ruling doesn't mean that there is a right that the complainant may simply put whatever questions it pleases to any witness. Have I got it right so far?
From our side, we think that is in line with your earlier proposal.
Yes. Thank you.
Can I raise a question of an attempt to be made to give us common cause facts?
Yeah, we can deal with that.
No.
I just want to clear this. Is there anything, is that okay?
No, that's okay.
Sorry,
yes.
Judge, just a question of clarity in terms of the order in which this will work. Would it be after the questions had been put by Judge Makhubele to the witness that we would then indicate to the evidence leaders and, if necessary, the tribunal, or would it be before that, so after the evidence leader has put questions? Or do you also...
Well,
yeah.
if there is a question or an issue left out by the evidence leader before she stands down, I think we would give you the opportunity to put the questions, and then we will allow the cross-examination. So we have the full evidence, and depending upon what comes out, we will deal with the situation.
Okay.
Then
Yes, that was my understanding, just to make sure that
Yes.
Judge Makhubele would be able to cross-examine after hearing everything, any questions that we might have put to the witness.
Yes.
Thank you, Chair. Maybe if I can just make a suggestion. Once I have finished reading the evidence of a witness, what I will request from the tribunal is whether I can maybe consult with the complainant's representative and find out if there's any, then we can take it from there. Thank you, Chair.
You are always free to consult with the complainants, with representatives.
I'm addressing the issue to all the parties involved in this matter. I raised the issue with my tribunal members this morning, and there seems to be no serious objection to me doing so. And the issue I really am raising is that we, as tribunal members, sitting with these papers from 2021. The papers are voluminous. Up to last Friday, I went to collect 2 volumes, 17 and 18, or day before. And what came to mind is this, that is there no possible way between the parties involved here to try at some stage to give us what may be common cause facts in this matter? I've had regards to the pre-trial minutes and other issues, but a lot of the issues in the volumes here are repeated. The complaint, I don't know how many times, and replies from this side to that side. It just came to mind that would it not be helpful in an effort to try and expedite the hearing of this matter for the parties to attempt to give us something that may appear or may be common cause facts in this issue, right from July 2017 up to March 2018. I'm sure there must be some smell of some common cause fact to curtail these proceedings. It could be done today, it could be done tomorrow morning as we resume, but I just thought that if we did that and we find that there are, in fact, not heavily contested matters, we can record that tomorrow and then we proceed with the evidence. I don't want you to do it now. It may be a new thing to you, but it worries me that we've been sitting with this matter for so long. The papers show that both parties want the matter to be brought to an end as soon as possible. And this is just but one way of trying to do so. I think I don't want an answer from them now, Chairperson. And is there a possibility of exploring that and coming back to us tomorrow morning or during the course of the morning and tell us these are common cause factors and dispense with this and that witness or this or that document, so that you all know where we stand? I know we can't finish this coming Friday, but for one reason or the other. But just a thought.
Well, the request really involves the evidence leader and those representing Judge Makhubele. You can think about that, or what is your view, Advocate Maleka?
Judge Jappi, we will try as much as we can to help the tribunal, especially to curtail matters that might not be expeditious. I'm reflecting on the issue now, but I think certainly in relation to documentation, we can prepare a core bundle of the documents that are not in issue.
Yes.
And in that way, we would be able to help the tribunal. But insofar as witness evidence is concerned, at this stage, I cannot formulate a view.
No, that's fine. Thank you. What's your view, Advocate Zungu? Do you think you'll be able to?
Thank you, Chairperson. It's a matter, the issue that has now been raised at this tribunal is an issue that I think we had tried to deal with at the pre-trial hearing on the 14th of November. I'm amenable. There is too many bundles that we are dealing with. There's also a lot of repetition of documents in regards to these bundles, making it even a little bit difficult with regards to also the leading of the witnesses. But something that also that has been brought to mind at this stage is that I hear Advocate Maleka and with regards to the witnesses that they intend calling, but it would have been of assistance as well since we had provided them with the list of witnesses and with the concise summary of the evidence of the witnesses that we intended to call. Maybe if during our discussions we go through this issue, because that will then enable us to deal with the issues and see which ones are common cause and which ones we don't need to lead evidence on. Thank you, Chair.
Yes, thank you. This doesn't quite involve you.
Well, Judge Japie, just to say that if there was a agreement of common cause facts between the evidence leaders and Judge Makhubele, the respondent, we would want to indicate if there are any of those that were not common cause with the complainant, because that would be important for the tribunal to know. So it seems that it might be useful, whether through the evidence leaders or otherwise, for us to assist in that. Otherwise, it may not achieve the intended goal. But we support the proposition. And as Advocate Zungu explained, that there was an agreement that from Judge Makhubele's representatives that they would provide a list of admissions, which hasn't been forthcoming.
Thank you. I think that satisfies you, Judge Mshidi. We will then proceed in the normal course today. Advocate Zungu, you will call your first witness. And at the end of today's proceedings, we will allow you time to embark upon the course suggested by Judge Mshidi. And you will let us know tomorrow morning if you would then require more time, or we will then just simply proceed. So you may call your first witness.
Thank you, Chair. I just wanted to find out at this stage, are you saying that at the end of the day, the Respondents' Council and myself will sit down and go through everything to determine which factors, but in the interim we lead the witness? Or is it proper, I'm just asking, would it be proper that maybe we deal with the issues, because maybe even the witness that we're going to be leading, there may be issues of common cause? I don't know, Chair. I'm in your hands.
Well, from my side, I would like this to be done first, but I wouldn't want to waste much time. If anything can be achieved today, we can then adjourn for today and allow you to embark upon the course that has been suggested, and let us know, well, as soon as possible tomorrow morning what you intend to do. We have to take into account that the complainant is also here with counsel and attorney. So we don't want to waste too much time. That is what's at the back of my mind. But I understand and appreciate the suggestion that you may try and use the rest of the day to work out what is common cause, and that would allow you to decide which witnesses to call and which witnesses not to call. And the same would apply to you, I suppose. What do you say, Advocate Malik?
Judge, we can use today to get to resolve that issue, and we'll be as much cooperative as we can on that issue. We leave it up to our colleague for the pro forma prosecutor to decide which witnesses they want to call.
I just want to re-emphasize that in terms of the legislation, we are not a court of law here. And these proceedings are supposed to be held as informally as possible and inquisitorial. If you're going to engage in this kind of process and you have problems, we should be available to help you today to reach such issues. We're not going to sit back and not take part in this thing. I mean, you can even call on us to help you and in resolving common issues or not and contested. But if the evidence leader, chairperson, is ready to call the first witness, I observed that the JP Mlambo is there. It may be that he's not available tomorrow. We may start with him today or something like this. But I'm just emphasizing that we are also here to help. We are not a strict court of law, and we can help you in reaching agreement on those potentially common cause or not common cause issues. That's our role here. But I suggest you go on with your witness, especially if there's a witness that may not be available hereafter or next week, or I think you must.
Well, you've heard what Judge Mashidi has to say, and Ms. Selevu is of the same view. Have you got any witnesses here today?
Yes, Chair. I've got the Judge President, Judge Mlambo.
Well, I think let's hear him, and then we will take it from there.
Thank you, Chair.
Yes, thank you. Good morning. It's still morning. We've got some time before we're into the afternoon. Good morning, just so that everybody knows, I do know Judge Mlambo, and I know him quite well. I don't think there's any objection to me taking whatever evidence he has to give. Well, my understanding is that the evidence is given under oath, so I'll have to swear you in. I never thought I'll see this day, but so be it. Yes, do you swear that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? Just say, so help me God.
So help me God.
Yeah. Thank you. Yes, Advocate Zungu. Yeah. You.
Chairperson, maybe before I started leading the evidence of Judge Mlambo, something that just came to mind.
Yes.
And I know that it is part of the bundle is with regards to the terms of reference of this inquiry and whether should we not at this stage maybe put those terms of reference with regards to the investigation process that we intend to lead at this inquiry.
Well, are you saying before you lead the evidence of Judge Mlambo, you would like to address the inquiry as to what you will be leading evidence on and what you hope to show the evidence will eventually show? Is that what it is that you want to do? No, I'm just asking.
It's just that, there's the terms of reference that are regulating this inquiry, and maybe it's best that we put them, place them before we start leading the evidence of the witnesses, because I've noted that at previous inquiries, there have been issues raised with regards to when these issues are not placed before the evidence is laid.
Yes, if I may just have a minute. What the evidence leader is proposing is to address the tribunal as to what the issues she sees as being the relevant issues before we take any evidence. I think it's probably a good idea, so we know what the case is about, and we will then hear from Advocate Maleka if he wishes to have any comment or add anything further as far as that is concerned. But in the meantime, I was under the impression that we were going to hear you, well, at least this morning. Judge Mlambo, if you could give us, stand down for about 15 minutes to half an hour, and we will recall you then again, if you...
Should I leave the room?
I think you better leave the room, yes. I think it's best. Yes.
Thank
you. Yes, Advocate Zungu.
Thank you. Thank you, Chair. The address is in terms of Rule 7.1 of the rules to regulate the procedures before the Judicial Conduct Tribunal. And Chairperson, I wish to make it very clear at the very onset that I'm not here in my prosecutorial capacity, rather as the evidence leader. And there is no charge sheet that has been compiled for the purposes of this tribunal. Rather, we are relying on the terms of reference that have been given us that this tribunal needs to deal with. So for the purposes, before we start leading the evidence of any of the witnesses, I believe that it's important that at this stage, I read out the terms of reference to this tribunal.
Yes, please proceed.
Thank you, Chair. The first allegation that one needs to look into is whether the respondent improperly held a dual status as a judge of the High Court of South Africa and chairperson of the Interim Board of Control of PRASA, and in doing so rendered herself guilty of misconduct as envisaged in Section 177 of the Constitution. The second ground that needs to be dealt with is whether the respondent's conduct as chairperson of PRASA was incompatible with the office of a judge, in that of all the cases that PRASA was involved in, she paid special attention only to those of CIA, that she marginalized the PRASA legal unit and terminated or caused to be terminated the mandate of PRASA's attorneys and personally appointed another firm of attorneys in their stead to represent PRASA, that she negotiated with CIA's attorneys and entered into a confidential settlement agreement that is manifestly and materially prejudicial to the interests of PRASA, relying on non-existent major concessions on its liability to CIA, allegedly made by PRASA employees at the insolvency inquiry, and frustrated PRASA's attempts to resist the enforcement of the settlement, thereby rendering herself guilty of gross misconduct as envisaged in Section 177 of the Constitution. Chairperson, the terms of reference are contained in Volume 3 of the bundles and are found on page 1057 to 1058. Chair, in trying to, in the evidence gathering and the witnesses that we'll be calling to deal with these allegations, we will be calling Judge Mlambo, we will be calling Judge Ledwaba, we will be calling Advocate Boetes SC, we will be calling Mr. Madimpe Mokhashwa, we will be calling Ms. Martha Ngoye, we will be calling Mr. Fani Tingeswayo, we will be calling Ms. Fogazi, we will be calling Mr. Ahmad. And those are the witnesses that at this stage that we intend to lead in regards to the factual finding position that we find ourselves in having to lead the evidence in trying to support the allegations that I've just read out to this tribunal. And Chairperson, in preparation for this tribunal, I want to make it clear to the tribunal that during the 14th of November 2022 pre-trial hearing, at that hearing there was a request that was made by the Respondents' Council, and we have submitted documentation that have formed part of the bundles in response thereto. There was also a concise summary of the evidence that we intended to lead in regards to the witnesses as well, and I also confirmed that they did request for certain further information that was submitted to them, and it was also forming part of the bundles. And at this stage, I do not see a need that I need to regurgitate all of that information for the tribunal because it is contained in the bundles that are before us. Thank you, Chair.
Thank you. Before I call on Advocate Malek, I just want to get some clarity. You've raised 3 points. Am I correct? That you intend to lead evidence on.
Yes, Chairperson.
One is whether Judge Makhubele had a dual status during the first half of 2018. Am I correct? It's really from January first to around when she was sworn in officially in June 2018.
Yes, Chair.
That's the first issue. Then, assuming you move on from there, that while she was the chair of the board of PRASA, she somehow favored Siaya, and that is that she paid particular attention to the concerns of Siaya. Is that a second issue? Am I correct?
That is correct, Chair.
And then the third issue is that she then entered into a settlement agreement with those representing CIA, if I may call that, which was to the detriment of PRASA, and taking all three into account, that she then rendered herself to be guilty of gross misconduct.
Chair, I would like to maybe correct the third
Yes.
one or
Yes.
amplify on the third one, that she negotiated with the CIA attorneys and
Yeah.
entered into a confidential agreement which was prejudicial to the interests of PRASA, relying on non-existent major concessions made at an inquiry, and also sidelined the internal legal counsel of PRASA.
Yeah, that's how I understood it.
Oh, okay.
You just given me the facts.
Okay.
I just wanted to know what the main issue
Okay,
was.
then I agree, Chair.
That is what you intend.
That is what I intend to.
Yes,
Thank
thank
you,
you.
Chair.
I don't think there's any, you have to establish anything. These are the issues that are put before us, and those are the issues we would have to decide. As
Ju-
you know, we act on instructions from the JSC, and the evidence leader has outlined what she intends dealing with. But I'm happy to hear you if there's anything you wish to add, and then I would allow Judge Mashidi to put any questions, and Ms. Salebu to put any questions. Is there anything you wish to say?
Just to be of assistance to
Yes,
the
certainly.
tribunal, with a view to telescope our lines of inquiries to various witnesses. We have looked at the terms of reference, and what we wish to bring to your attention now, so that you understand our line of examination going forward, is this. If you look at 5.1,
Sorry, just give me the reference again.
page, volume 3,
Bundle
page 1033,
Yes.
paragraph 5.1.
Yeah,
The allegation or the complaint is that Judge Makhubele had occupied a dual status as a judge and at the same time as the chairperson of the interim board of control of PRASA. So that the lines of inquiry we're going to explore relates to the factual question whether she did, as a fact, occupy that dual status.
yes.
The second point we'd like to draw to your attention is 5.2. And in its terms, it says whether Judge Makhubele's conduct as a chairperson of PRASA was incompatible with the office of a judge. We read that part of the terms of reference to raise yet again the question of dual status. So that at the end of the day, if the evidence establishes that she did not occupy a dual status, both 5.1 and 5.2 must fall by the wayside.
Yes.
And that will be the line of inquiry we're going to adopt. And we hope that that will assist you as and when we get to each witness. Because 5.
As I understand it, if she was not a judge
Yes.
between January and June, that's when she was sworn in, according to the papers that we have, she really doesn't fall within the jurisdiction
Indeed.
of the JSC.
Indeed.
That, I understand, would have been part of the attack. I'm not saying it's the whole attack, but it is
Indeed.
part of the
Indeed.
attack. Yes.
And therefore, it's irrelevant what you would have done in her capacity as a chairperson.
Well,
of
that's a
trust.
matter for argument,
Indeed.
yes. But basically, everything turns on the first point
Indeed.
outlined by the evidence leader.
Indeed.
That is how you understand it,
Yes.
and I have no quarrel with that.
Yes.
I don't know if the other members of the tribunal will have it. But it really depends upon the first issue,
Indeed.
as it is. If she was not a judge, then we have no jurisdiction over her.
Indeed.
That is, well, that's how I understand it. the
That's
matter.
how we understand it too.
Yes.
Yes.
Yeah.
Sorry, Judge.
We will get,
Okay, thank you.
is there anything you wish to add?
Just very briefly, I know that J.P. Mlambo may not or is unable to give evidence on what is referred to as Part B of the complaint. Madam Evidence Leader, but what I want to know from you is the allegation there is about Judge Makhubele getting involved with the SASA or CIA group matters when she got to Prasa, is that right?
Yes, Judge.
The simple question from me is whether the CIA group matters were the only matters that were in litigation at that stage, because we hear later on that some of these matters were settled and some were not settled. I think between 4 and 5 matters or so. Was the CIA group matters the only matters involved, or were there other matters as well? Because the allegation is that she singled out the CIA group matters and concentrated and did all sorts of things and settled, and were those the only matters she interfered with? That's what I want to know. It's not clear from the papers.
Sorry, Judge Mashidi, that is what we intend to lead, that in as much as there were other legal matters that were proceedings, but the CIA matters are the ones that she singled out and dealt with.
I want to understand how the allegation comes that she concentrated on the CIA matters. Were there other matters that were pending in court that Prasa was being sued for and taken to court?
Yes, Judge Mashidi, there were other matters that were proceeding in court, but the matter that we are saying that she concentrated on is the CIA matter.
Okay, we'll get it from the witnesses. Maybe we're not on the same level. We'll get it from the witnesses if they do come and testify. Thank you.
So,
There's one more
If-
question from
If I may, out of those matters that you say there were, are you abandoning them, or are we focusing only on the CIA? We do not want a situation where all of a sudden you bring up something new while we are in the middle of the proceedings. If you want to take some instructions or just to, that, I'm not sure whether that suggestion would suffice for you.
Thank you, Ms. Silevo. You know, we've really concentrated on regards to the terms of reference and with what we were supposed to investigate with regards to the whole, with what we were being given the allegations. We did canvass the issue with the witnesses, but it is the witnesses will testify in regards to the CIA matters, and the question will be posed with regards to the other matters. But what we got from our witnesses is this is the matter where the concentration was given to. Thank you.
Sorry, Judge Chappie, just to ensure that there's no misunderstanding when it comes to argument at the end of the tribunal, we view the relationship between the two parts, the Part A and Part B as they're called in the complaint, differently. In our view, and what we're going to argue to the tribunal after the evidence is led, is that Judge Makhubele's conduct at PRASA as a chairperson, whether she became a judge on the 1st of January or the 8th of June or the 1st, whichever date, renders her unfit to hold the office, and is that it's a person who's exhibited that type of conduct is unfit to hold office. So that just so it's clear, that's going to be our argument. That's always been the position of the complainant. And also just one other point, that the conduct continues over from 2017 into March 2018, when there's the situation with the attempt to enforce the order and her Judge Makhubele's participation in that. So just so there's no misunderstanding, that in our view, the whole case does not turn on the date on which he became a judge. I accept this is a matter for argument. I just didn't want there to be a misapprehension at the beginning.
Yes, no, I'm concerned with for the moment, the evidence that was going to be led. When we get to argument, we will deal with what the complainant's complaint really is all about. If it has been put any other way, speaking for myself at the moment, you will be given an opportunity to correct it, and we will report, because that's what we are here to do, to the JSC.
Thank you, Judge.
On what the position at this tribunal is. Thank you. Call Judge Mlambo now. Is there anything else you wish to add?
We can call Judge Mlambo.
Yes, thank you. He has been sworn in, so you may start with him. Thank you, Judge Mlambo. We are ready for your evidence. Thank you. Yes.
Thank you, Chairperson. Okay. Thank you. Judge Mlambo, is it correct that you know the respondent, Judge Makhubele, in this matter?
Yes, I do.
And on the 4th of October 2017, we had the JSC interviews take place for the placement of judges. Did you sit at these interviews?
Yes, I was part of that interview on that day.
Was Judge Makhubele one of the candidates that was interviewed on that day?
She was.
Now, prior to this interview, you've indicated that you knew her. How did you know her?
I knew her as counsel. Now she's one of the few silks and black at that who actually led some teams in matters before the High Court. But I knew her more as an acting judge because she gave up most of her time. Well, let me not say most. She is one of those silks who gave me time to come and act in the division.
After this interview of 4 October 2017, are you able to explain to this tribunal or outline to this tribunal what exactly then happened after that interview of the 4th of October 2017?
Thank you. I think leading up to the interview, after Judge Makhubele was shortlisted, I recall that she spoke to me. She is the one who approached me to just check what would happen in terms of starting dates, were she to be successful in the interview. And I told her that in Gauteng, the divisional policies that candidates recommended in October should wind up their practices and be ready to assume permanent judicial office by the 1st of January of the following year. So that's what I informed Judge Makhubele. And she stated that she may not be able to start on 1 January 2018. And when I asked her what would be the reason, she said because she's the chairperson of the Water Tribunal. I poured cold water over that. I said, at that stage, it was still early, even before the interviews, I said, her role as chairperson of the Water Tribunal is judicial office. And I saw no conflict in her doing that work, even if she were to be recommended for appointment or even appointed. Because as JP, I would make arrangements to give her time to attend to whatever outstanding work there would be in her role as Water Tribunal chairperson. We left it at that. Come the interviews, and Judge Makhubele was recommended. And as part of divisional policy, immediately after candidates are recommended, I get in touch with them to sort of tell them what to do pending them taking over permanently. And I think I sent a letter to all recommended judges on the 19th of October, telling them, one, that their start date would be 1 January 2018. And that's based on me writing a letter to the JSC, which forwards that letter to the Minister of Justice, because they always ask us, when are the recommended candidates to start permanent judicial office? So I think by the 19th, I would have already sent the letter that their start date would be 1 January 2019. So I sent that directive, and it dealt with a number of things. One was that I look forward to welcoming them, and that sometime in early January, I would expect them to come into my chambers to take the oath of office, that they would be expected to choose chambers, although that there was a pecking order, that they would have to appoint or choose secretaries who would work with them. They would, if they were interested in joining the judges' vehicle scheme, that as early as that, they should start making up their mind what vehicles they wanted to have that would be procured for them. I also informed them, I think I attached a resolution that was adopted by the heads of court some time ago, based on the cost containment initiative in this country, that in choosing a car, they were not beholden to choosing the most expensive car, even though they were allowed to. But just bringing those things to their attention, I even informed them that in their chambers, if they chose a chamber that has a physical library, that would be the status quo. But we had stopped providing physical libraries to chambers because those are expensive. So that's the directive. It covers most of those things that I sent to them. The idea behind that is for those colleagues who are about to become permanent to wind up whatever they were involved in and to get out of appointments or matters that they were busy in, to hand over or pass over the briefs if those matters were happening after that date. A number of things, but the idea behind it is that when they start clean. When I say clean, is they have nothing else from an income earning perspective that they are still attached to when they start. So I think I then proceeded to prepare the duty roster for term 1, 2018. And in that term, that duty roster, I included all the newly appointed judges. I allocated work to them. Now, I think, if I recall well, when I circulated the other part I dealt with in the directive that I sent to the recommended colleagues was how I was going to place them. I was placing Judge Makhubele with two other judges in Pretoria, and I was placing other judges in Johannesburg, and I requested them to confirm to me that that placement was okay with them. Judge Makhubele confirmed that her placement in Pretoria was okay with her. Now, after I circulated the draft duty roster, and I think that was in the first week of December, I think I had email communication with Judge Makhubele. I think she confirmed that her placement in Pretoria was okay with her, but she said she requested that I put her starting date or her commencing with her appointment on 1 January 2018 on hold, as she was involved in a number of things. Now, I can't remember the sequence, but I'll be happy to be reminded. But I think I responded to say we could meet. No, I think she wanted to meet. I said no, she could write because I was busy. I don't think she wrote to me to say what her reasons were. But I know that the secretary who was allocated to her started sharing her files, especially her appeal files, immediately after I issued the final duty roster in which she was allocated work.
Thank you, Chief. Thank you, Judge Mlambo. At that stage, I just wish to assist here a bit. Is it correct that you submitted an affidavit in preparation for this tribunal?
Yes, I did.
And is it I want to refer you to volume 10 of the bundles, page 1. And can you confirm whether that is the affidavit that you submitted together with the attachments thereto?
As soon as I have it, I will look at it and confirm. What volume is it? Sorry?
It's volume 10.
Volume 10. This would have been easy if it was online, you know. But Thank you. What page did you say?
Page 1.
Page 1, yes. I've looked, I've seen the affidavit, yes. I deposed to this affidavit.
You deposed to that affidavit, and if you go on to page number 9, you confirm that document?
Yes, that's the directive I was talking about that I sent to the newly recommended judges, yes.
Now, I'm going to refer you to volume 5 of the documents, and I want to refer you to page 637. Volume 5, page 637.
Thank you. 637. Yes, I've got page 637.
Thank you. Is there are those copies of emails on page 637?
Yes, these are, I think, the first one is the one at the bottom. It was sent from my office by one of my clerks to all the judges, to the newly recommended judges, attaching that directive that I spoke to. And the top one is an email from Judge Makhubele, wherein she, as I said, accepted her placement in Pretoria and that she wanted to have further discussions with me. Yes, I confirm those emails.
Okay. Judge Mlambo, just with regards to the email at the bottom dated the 19th of October 2017 at 12:09, the subject heading there is written Directive for Newly Appointed Judges. And you've just now indicated to the members of the tribunal that it was sent to the newly appointed judges. Am I correct that the document which appears on page 10, is that the document you're talking about that was attached? Page 10 of volume, page 9 of volume 10.
10, yes, that's the document.
Chair, I just want to maybe pause to assist the colleagues that if they've got it. I see Mr. Malega. Do you have to, are you okay? Okay. Judge Mlambo, back to volume 5 of that, of volume 5 on page 637, the email on top is dated the 20th of October 2017.
Yes,
And it is from Titswalo Makhubele.
that's Judge Makhubele, yes.
Thank you. Judge Mlambo, what does that email say to you?
Well, I think as I said short while ago, I said she thanked me for her for support and recommendation, and that she's glad to accept the placement in Pretoria, and that she would like to have further discussions with me regarding the starting date of her appointment. And then she asked whether she was compelled to purchase a new vehicle or whether she could just claim allowance. And she stated she looked forward to meeting me soon to discuss the matter in one. That is her starting date.
On page 639, there are further emails of volume 5.
Yes.
The email I want to have, did you respond to the email of Judge Makhubele of the 20th,
Of the 20th,
at
yes.
6:27, you then responded, am I correct?
Yes, I responded on the 23rd of October, and I clarified that she wasn't compelled to procure a vehicle and that she could, using her own vehicle, and claim S&T. And that's when I said she must indicate what her view was regarding a starting date via email, as I couldn't meet her. I was busy.
Further to that email, if you look on top of that page of page 639, there's a response email, follow-up on that email. What
Yes.
date is that email?
It's the 4th of December, 2017.
And who responded?
It's Judge Makhubele.
And what does that email say?
Well, she said she apologized for taking time to respond to my email, which was the email of the 23rd of October, that she had to do much reflection on the matter, taking into account all the positions that she was currently occupying. And then she stated that after much reflection and considering every aspect of the challenges, she thought it would be in the best interest of the bench if she started in April 2018. And then she said that she trusted that this would be acceptable to me and that she was still hopeful to a meeting with me to explain the challenges.
Now, between the email of 23 October 2017 and the email of 4 December 2017, were there any discussions between you and Judge Makhubele?
I stand to be corrected. There may have been, but I can't remember any. I can be reminded, but I don't recall any particular discussion.
I want to refer you to volume number 18. Volume number 18 of the volumes, with specific reference to page 1.
Page 1, yes.
Yes, have you got volume 18?
Yeah.
Judge Mlambo, on that specific page, there's an email dated the 6th of December 2017.
Yeah. Yes, that's my email to all the judges circulating the final duty roster, I think. No, sorry, it was a draft duty roster, not the final duty roster.
Was there a response to that email?
Yes, I think at the top email there is an email from Judge Makhubele, which was the next day on the 7th, when she said, "Thank you for your email. I have noted the allocation. I request that you place me on hold until we finalize the discussion about my application to start later than January 2018.
Now, was there any further email discussions between you and Judge Makhubele thereafter?
As I said, I don't recall that there was further email discussions, but I think I called her in the second week of January 2018, as she was the only newly appointed judge who had not come in to take the oath of office. And the purpose of my call to her was to find out why she hadn't and when she would be coming. And she stated that she had told me that she would not be starting on 1 January 2018. And I informed her that I had told you that based on the reason you gave me for not starting on that date, I had not approved it. So I expected you to be here. So I said to her, you must come and take the oath, right? And then she asked for a meeting with me to discuss this issue further. I then arranged a meeting where she was going to come and see me in my chambers. I can't remember the specific date when that meeting happened, but it happened, and I requested Deputy Judge President Lidwaba to be present at that meeting. And Judge Makhubele came, and we discussed the matter. I again asked her why she had not come in, because she was on the duty roster. I expected her to take the oath so that everything was in order when she started her work as a judge. And she again told me that she had told me that because of her water tribunal responsibilities, she would not be able to start. And I told her that I had rejected that reason as no reason, because there's no conflict, as far as I'm concerned, between her job as water tribunal chairperson and judge. And then she persisted that she would not be able to start. And we pressed her of the true reasons, because her water tribunal reason I had rejected. She simply said, no, she can't come. Until I broached the issue of her interim board chairpersonship of PRASA. I said, are you not able to come because you've accepted a position based on what I've read in the media? Then she said, yes. I said, but I think I voiced my complete disappointment that she had accepted that appointment, having known from early October that she'd been recommended for permanent judicial office. And my biggest disappointment was that there were a number of matters in the division involving alleged corrupt activities at PRASA. And I say that was my biggest disappointment, because I specifically said to her, how could you go and join an organization that was featuring in this division where you are appointed as a judge, which is not cast in good light in the public domain about what's happening there? She stood by a ground that no, she wasn't able to start 1 January, and that she'd accepted the appointment, so be it. We tried to reason the matter with her until DJ Pilidwaba asked her, but why? Why can't you get out of PRASA? It's still early. And she said in response that she didn't want to disappoint the minister.
I just want to interject you for a moment, Judge Mlambo. Her position with PRASA, when was it first raised and who raised it?
It was raised by myself in that meeting.
And that meeting was in January of 2018.
Yes.
Before that, she had never raised it with you.
Never, ever.
Thank you.
So, when we realized in the course of that meeting that we were unable to persuade her, because, as I said, her water tribunal responsibilities posed no issue. It was the PRASA issue that really, I think, stood in her way in terms of coming to take permanent judicial appointments. So we realized that we were not able to persuade her, and then I then said, okay, I will write to the minister to request that your appointment date be changed. I think the word I used in the letter I sent to the minister was deferral. And I did that letter on the 22nd of January, I think.
Judge Mlambo, I'm going to refer you to volume number 5 on page 642. Sorry, on page 640 to 641. Volume 5, page 640 to 641.
Yes.
Is that the letter that you are referring to?
Yes, that's the letter I'm referring to.
Okay. After this letter had been sent to the minister, sorry, before I get to that question, Chairperson, you indicated just now that you then requested that a deferral of the appointment. Is that correct?
Yes.
Right. And in paragraph number 2, Judge Mlambo, line number 1, 2, 3. Maybe can you just read out paragraph 2 for the purposes of the tribunal?
It reads thus: Madam Justice T.A.N. Makhubele approached me after I had notified the ministry of the appointment date of all newly appointed judges of this division. She will require a few more months to fulfill all her tasks as chair of the Water Tribunal, and has kindly requested that her date of appointment be amended to commence on the 1st of April 2018 instead of the 1st of January 2018.
Well, if you look at paragraph number 2, Judge Mlambo, was there any specific reason why you did not include the issue of the fact that why she said that she was also sitting as chairperson of the water board? Chairperson of the interim board of PRASA?
I don't recall why that was not mentioned in the letter. I can't think of any reason why it was left out. But this is her official position throughout my discussions with her, that she wanted to be given time to finalize her water tribunal issues.
Okay.
Judge Mlambo, as far as the water tribunal is concerned, your view was that she could still take up a position as a judge as from the 1st of January. The tribunal wouldn't have had an impact on that. Is that correct?
That is correct, yes.
And up until January, when you had this meeting, I think the meeting was 7th of, no, your meeting with her at your chambers, when was that?
First week of January.
It was the first week of January.
I don't think it was the first week of January. It was any time between the 2nd and the 3rd week of January. I can't remember the date.
That was my understanding. She
Yes.
hadn't come in
Yes.
to take the oath shortly after the 1st.
No.
And when she didn't come, by the 2nd week of January, you called her.
Yes.
Is that it?
That is, yes,
She
that's
didn't
correct.
ask for the appointment. You asked her to come in and explain
Yes,
why she didn't come in to take the oath.
yes, that's correct.
And it's at that meeting that the DJP was present. Is that correct?
That is correct, Chairperson.
And it was then discussed with her why she didn't take the oath.
Yes.
And what was your understanding of the reason she gave you during that 2nd week of January why she had not come in? Did she give a reason?
No, her reason, Chairperson, continued being her outstanding responsibilities at the Water Tribunal.
And it was limited to that?
Yes.
And
She may have mentioned that she had 1 or 2 other matters
Yes.
that she was involved in as counsel, but she could give me no dates, whether there were any dates of enrollment or whatever.
And then you raised the issue of PRASA with her?
Yes.
As I understand your
Yes.
evidence. What did she say to that?
No, she admitted, because I said to her, are you not able to come, because from what I've read in the media,
I see.
you've accepted an appointment as chairperson of the interim board of PRASA. And she admitted that she'd accepted that appointment.
Yes.
And we said, but that's when we questioned why, the prudence of her accepting that appointment. We debated that for some time. And then that's when even the DJP asked her why she couldn't come, and she said she didn't want to disappoint the minister.
Can I just ask you about the DJP's response?
Yes.
He had expected her, from my understanding of your evidence, to have come to Pretoria shortly after the 1st or from the 1st of January. Is that correct?
He had the same expectation as me, because I think up to that time, we in the division didn't put newly appointed judges in the recess duty roster.
Yes.
The court was still in recess. So there was nothing compelling judges to come in physically. But the expectation was those who were newly appointed were meant to come in to take the oath.
Yes. She did not come in. You had a meeting in your chambers, and it was at that meeting that you raised the PRASA situation with her. She didn't raise it with you.
No, she didn't raise it with me, Chairperson.
Yes. And was that the first time that you actually knew she is continuing as the chairperson of the interim board of PRASA?
Yes, because she confirmed to me that I'd read the media reports, but
Yes.
after reading the media reports, I could have called her and say, I'm reading this, what's happening? I didn't, because I thought she was prudent enough to understand that she's coming into a judicial appointment. She can't have anything to do with appointments like that. So that's why I didn't. And when I raised it and she confirmed it there, that was the first time she officially confirmed to me that she was in that position.
And that was after the 1st of January, 2018.
That is correct, Chairperson.
Thank you.
Thank you. Judge Mlambo, after you had written this correspondence to the minister, what then happened?
Well, in that same letter, I'd asked the minister to appoint two practitioners, one Advocate Wanless and then Magistrate Shanaz Mia, to fill in her slot for that term, because she wasn't going to be there. Someone needed to do her allocations. And then I left the matter at that. I didn't get a response from the ministry, but at some stage, I can't remember the date, but there was a discussion between me and the minister when the Minister Masuta raised the issue of the deferral. I think he actually used the words, you are seeking to revoke her appointment. And his disquiet was, if you revoke, that means she can't start on 1 April, because revoke means cancel. For her to come back, she'll have to go for another interview. And I think I said to her, sorry, Judge.
For another what?
Hello?
She had to go for another what?
Interview before the JSC. So that was the minister's concerns, to say if it is to revoke, that's the interpretation he gives to this thing. And I said, but Minister, if you look at my letter, it says deferral. It defers the date when she starts. It doesn't challenge her appointment as such. And then we agreed at that discussion with the minister that the department was going to seek an opinion in order to properly advise the presidency about what to do. And the opinion was sought, but it took time for the opinion to come. Even before that opinion came, Judge Makhubele wrote to me, I think there's correspondence to that effect, wherein she was asking me to say she's resigned her positions and she's ready to come on 1 April. And I said, I've asked for a deferral of your appointment. I've not got a response. I've been told there's going to be an opinion sought. I can't allow you to come back until that part of the issue, of the matter, is resolved. I think she voiced her concern that she was going to be sitting without income as she's resigned herself from all her positions. I said, well, I can't do anything. And that situation was addressed in May when the presidency sent in another appointment certificate with a minute.
Judge Mlambo, did you have sight of that legal opinion from that the department had sought?
Yes, I've seen the opinion.
And what were the findings on that opinion?
I think without reading it, it must be somewhere in the papers. I think the issue that the Chief State Legal Advisor grappled with was whether it would be necessary for the presidency to get a court order to set aside the appointment or the date when Judge Makhubele was to assume her duty from January to April as requested by her. That seems to be the main issue that the Chief State Law Advisor was concerned with. And at the end of it, the conclusion was that it was not necessary for the presidency to go to court to get an order to change the date. If I remember the words of the opinion, it was that the appointment date is one part of the appointment process. That being the reason, it was not something that required the presidency to go back to court to get an order changing his decision to appoint her on 1 January, but to appoint her on a different date. That's my understanding of the opinion.
Chairperson, if you could just bear with me, please. Thank you.
Could I ask a question whilst you are looking for your papers?
Please, sir.
JP Mlambo, would it sound too simplistic for me to say that when it became evident to you that Judge Makhubele could not start on the 1st of January 2018, to have referred the matter back to the JSC? Or is it too simple to say? Instead of you now writing to the minister and involving yourself, going out of your way, you're sitting with an appointment from the president to say 1 January 2018 you start. But you now get involved in the reasons for her not starting, you find out about PRASA, you talk about the Water Tribunal. Would it not have been better for you, in your busy position, to have referred the matter back to the JSC, there and there?
I don't think one can refer to it as simplistic. It's something that never crossed my mind, and I can explain why it never crossed my mind. Once the JSC has recommended persons to be appointed permanently, the focus of the communication becomes the ministry and the respective judge president. That's why the ministry would write to the judge president to say, when are these newly appointed judges starting? It doesn't write, the ministry doesn't write to the JSC, because the ministry is the gateway to the presidency in finalizing that whole process. So it never crossed my mind, I'd never done it, and in any way, it's informed by the communications that we as JPs always have with the ministries when it comes to the appointment, mostly of acting judges, right? And granted, the JSC is not involved there. But as I say, I don't think it's simplistic. It's something that perhaps could have featured, but I think the ministry would have received the correspondence from the JSC, but would have still come back to me as head of the court. So it never crossed my mind for those reasons.
Well, I know that you became JP whilst I was there, Johannesburg High Court. Has it ever happened that you had a newly appointed judge not being able to start doing work on the appointed date? Or were there other people as well who asked for extensions for this or that reason?
Up to that time, it had never happened. Up to that time.
Thank you.
Just to clarify, JP Mlambo, so this was the first occasion
Yes,
where somebody has been appointed and you had to deal with the situation where that person, after the appointment, could not take up the appointment for whatever reason.
yes.
And so when you wrote to the minister, this was all new. Is that correct?
That is
You-
correct. It never happened before,
Yes, thank you.
Chairperson.
Judge Mlambo, did you then, you indicated that you received back you did have sight of the legal opinion. I'm going to refer you to volume 2. I don't know if you have it before you.
I think it's the first one. Yeah, I've got volume 2, Advocate Zuma.
And you've had sight of the legal opinion,
What page is it again?
756.
Yeah,
Okay. And after this, and you had sight of this legal opinion and the findings thereof?
yes.
Okay. And after this legal opinion was submitted to yourself, or you received the legal opinion, did you indicate that you thereafter received the new appointment?
Yes.
Now, I want to refer you to volume 4, on page 402. The President's minutes.
402.
I interrupt, Judge Mlambo, you can have a look at the President's minute, but I'm told that we have to adjourn. It's, apparently the hotel is ready to give us lunch. So, so could we adjourn for lunch, and could you all be back at 2 o'clock? Does that suit you, Judge Mlambo?
I'm at the behest of this tribunal.
Yes, we then stand adjourned till 2 o'clock or as soon thereafter as possible. Okay. Thank you, Judge Mlambo. We resume after lunch. You may carry on, Zungu.
Thank you, Chairperson. Before the lunch adjournment, Judge Mlambo, I had referred you to volume 4 on page 402 of that volume 4, page 402.
Yes, I've got it in front of me.
Then that document is noted at the President's Act number 97, the President's note.
Yes, that is the correct. Yes.
I would like to refer you to I would like you to kindly indicate to the tribunal what that document is stating.
Should I read it?
You can read it out.
Thank you. President's Act number 97. Whereas on 1/2017, I have, in terms of the President Act number 357, appointed Madam Justice Tintswalo Anna Nana Makhubele as a judge of the Gauteng Division of the High Court with effect from 1 January 2018. And whereas Mr. Justice Dunstan Mlambo, Judge President Mlambo of the Gauteng Division of the High Court has, at the request of Madam Justice Makhubele, requested that the date of 1 January 2018 be amended to a later date on which the appointment will take effect. Now, therefore, I hereby amend the date of appointment of Madam Makhubele to be 1 June 2018, given under my hand and the seal of the Republic of South Africa at Pretoria.
Thank you, Judge Mlambo. What did this mean?
Well, my understanding is the President acceded to my request to defer the date of appointment, the commencement date of Judge Makhubele's judicial appointment to 1 June 2018, from 1 January 2018.
The document is dated as 22 May 2018.
Yes.
What position was, what was the position of Judge Makhubele then between 1 January 2018 and the date of that document?
In my view, she remained appointed a judge.
Just to get clarity on that, when you say, in your view, she remained a judge, from when?
From 1 January 2018.
And what, in your view, was the effect of this latest missive, if I may call it that, or latest appointment by the President? What does that mean for your interpretation?
My interpretation, Chairperson, was that the act of appointing her as judge
Yes.
remained extant throughout. What changed was the date when she was going to assume and start performing the job of a judge. And that's what explains my view, that changed to 1 June 2018.
Thank you.
Thank you. Judge Mlambo, I want to refer you to page 395 of the same bundle.
I've got it in front of me.
We see a President's Minutes number 357.
Correct?
I want you to please read out from I hereby with A and then the paragraph number 8, which refers to Advocate Tintswalo Anna Makhubele.
It reads thus, President's Act number 357, I hereby, an A, in terms of section 174(6) of the Constitution of the Republic of South Africa, 1996, and on the advice of the Judicial Service Commission, appoint, and Roman figure 8, Advocate Tintswalo Anna Nana Makhubele, SC, as a judge of the Gauteng Division of the High Court with effect from 1 January 2018 in an existing vacancy.
And when you read the two presidential minutes, number 357, which is dated the 1st of November 2017, and the one dated 22 May 2018, is there a difference between the two?
Well, the only difference is that that paragraph that says, now therefore I hereby amend the date of appointment of Madam Makhubele to be 1 June 2018.
I want to refer you to the Constitution, the book, Judicial Regulatory Instruments, Section 174.
Thank you. What page, sorry?
Page 86. Sorry, starting on page 85, Section 174 of the Constitution. Now, Judge Mlambo, if you read Section 174.1, Section 174 of the Constitution deals with the appointment of judicial officers. Section 174.1 of the Constitution states as follows: any appropriately qualified woman or man who is a fit and proper person may be appointed as a judicial officer. Any person to be appointed to the Constitutional Court must also be a South African citizen. If you go on to page 86, subsection 6, it states as follows: the President must appoint the judges of all other courts on the advice of the Judicial Service Commission. (178) deals with before judicial officers begin to perform their functions, they must take an oath or affirm in accordance with Schedule 2 that they will uphold and protect the Constitution. I want your understanding of these two sections, especially Section 174.6 and Section 174.8. What is your understanding in regards to these two subsections of Section 174 of the Constitution?
My understanding is that the appointment of a judge goes through a two-stage process. The first stage is the appointment itself. We could say it's a three-stage process. The first stage will be the recommendation by the JSC to the President to appoint a particular person as a judge. That would be the first stage, if we say three stages. The second stage would be the President appointing on the basis of that advice. And the third stage would be the person appointed taking an oath of office as a judge.
And what is the purpose of the oath of office?
The purpose of the oath of office is that until and after you've taken the oath, you cannot perform any judicial functions whatsoever, irrespective of whether you are appointed or not.
If I'm understanding you correctly, you cannot, no.
You cannot sit in a case and adjudicate a case unless you've taken the oath of office.
Does an oath of office affect your appointment?
No, it does not. All it means is until you've taken that oath, you can't be allocated any work. you remain appointed a judge. That is when we talk about permanent appointment of judges.
Now, I'm going to refer you again to the same judicial regulatory instruments. I want to refer you to the to the Code of Judicial Conduct. It is found on page 300. Well, starting from the page 299, which is the black page. I want to refer you with specific, taking into consideration that the evidence that you've just provided or you've given to us since the time that the evidence has been laid, you've indicated that Judge Makhubele was a judge as of 1 January 2018. The Judicial Code of Conduct the Code of Judicial Conduct, sorry. The Code of Judicial Conduct. I want to refer you to page 302, Article 2, that deals with the application. And I want you to refer you to Article 2.2 there. What does it state?
It says a judge not on active service is bound by this code insofar as applicable.
What does that mean? What is your interpretation of that?
Well, I remember writing a judgment about these issues. What it means is that this code applies to judges in active service. That is, inactive service means if you are still performing judicial functions, you're not retired. If you are no longer in active service, you are retired. That means you are not subject to any allocations by any head of court, but you remain appointed a judge. That's why the code remains applicable to you.
Okay. I want you to take you to Article number 12. That is found on page 3.10, but with specific reference with regards to 12.2, which is found on page 311. So a few pages later. Have you found same?
Yes.
Thank you. Please, can you read that out?
It reads thus: a judge must, upon permanent appointment, immediately sever all professional links and recover speedily all fees and other amounts outstanding, and organize his or her personal business affairs to minimize the potential for conflicts of interest.
I want to understand this, Judge Mlambo. When does a person really implement that section 12, that Article 12.2?
My understanding of it, and that's how I've applied it, is that upon anyone being appointed, it starts from knowing that you've been recommended for permanent appointment, that you start severing all links that you may have to private professional business that you may have. You may be a director in particular companies. You may be an advocate to recover fees, to resign from those professional bodies. That is to wind down whatever you were doing in your private capacity as a citizen of this country. Because when you become a judge, you become subject and answerable to the Constitution. You can only have one income. If
in the present instance, we've been, the evidence you've given is that Judge Makhubele was appointed on the 1st of January 2018.
Yes.
Article 12.2, would you be able to implement it after that appointment? Or would it be something before?
I don't think I understand what you're asking me.
Article
Advocate.
12.2 says they must do certain things.
Yes.
Now, are those certain things only done after the appointment date, which in this case would have been the 1st of January 2018, or would it be applicable before?
Well, you severe all these things before the date comes into effect.
If I may, it just reads, a judge must, upon permanent appointment. So the duty falls due once you are appointed.
Yes.
So the appointment in this case, from what we've heard from you, would have been the 1st of January.
Yes.
Is my understanding in line with what you're saying, that upon the 1st of January, this is what should have occurred?
The way I've applied it,
Yeah.
Chair, is you know, even before the date of
Yes.
effect of your appointment, that you've been appointed permanently.
Yeah.
And your duty is to ensure that when that date comes, you are out of all those things. That's how I understand it.
Thank you.
Now, I want to refer you to same volume, volume 4, that we were busy on. I want to refer you to page 119. Chair, this is the document, which is an affidavit in the review proceedings. It's an affidavit by Judge Makhubele in the review proceedings that were instituted in November of 2020.
I'm battling to find that page because there are a number of page or indexing scenarios here.
At the bottom of the page, it's a typed on the bottom of volume 4.
Typed, okay. 119, you say?
Yes, page 119.
Okay. I think I've got it. Yeah.
This affidavit was prepared by Judge Makhubele in the review proceedings that were instituted in the High Court in Gauteng. I want to make reference to a certain paragraph of that affidavit. I want to refer you to paragraph 23.
Yes, I've got it.
Although I delayed in giving the Judge President a written note on when a convenient date of commencement would be for me, I had verbal discussions and meetings that were attended by the Judge President and the Deputy Judge President, in which my issue of when I could assume my judicial appointment. Both were willing to assist me to obtain a date for my judicial appointment that would accommodate my needs. How many meetings did you have with Judge Makhubele where Judge Ledwaba was present?
Just one.
And I want you to indicate whether you agree with the comment or the statement made there that both were willing to assist me to obtain a date for my judicial appointments that would accommodate my needs.
No. If it applies to previous discussions, that's not correct. What is correct is that when we failed to persuade her to start to start like anyone else and take the oath in January 2018. That's when I decided to write to the minister to defer her date of appointment. If you refer to that as willing to assist, yes, but that's what I did.
Okay. And then I want to refer you to volume 5 of the documents.
Volume 5, okay. Yeah, I've got volume 5, thank you.
Volume 5 of the documents, Chairperson, is an extract from the Zondo Commission of the evidence that was given by Judge Makhubele at those proceedings. I want to refer you with specific reference to starting from page 555.
Page 555.
It's again typed at the bottom.
I've got it.
Okay, and I want to go to from line 14, so that I can contextualize this evidence properly. Judge Makhubele testified at the Zondo Commission and indicated, and I immediately wrote to JP by return email to say, well, I accept that you want to place me in Pretoria, and asked other questions. And then I said, but JP, with regard to the dates, can I have a discussion with you? If you remember, we had a discussion. I want to meet with you with regard to the effective dates. And remember, Chair, by then, the President had not yet signed. Then according to that letter, so JP said to me in reply, Nana, I am busy. Put your thoughts about the effective dates in writing, which I did by return mail to him to say, JP, remember, I agreed that I want to start on the 1st of April for these reasons. And we then further exchange, further exchanges between us, and apparently in between, maybe because of my delay in responding to him, because there's one email he said I responded late. The President has already put the date of 1 April. We then had further meetings with the JP, and until we came to an understanding that he will engage the Minister of Justice to ask the President to change the date as I requested.
Yes.
Do you follow with that one?
Yes.
Then I'm going to take you to line number, same page, 3556, 15, where it says Judge Makhubele in the middle of the page. Many requests, sorry, I think I'll just continue from line 10. And obviously I had to ask JP, but JP, why did you not give the President from the beginning a date? And then his reply was that no, he received many requests, and there's a break. Many requests, and then he wanted, I don't know what but the long and short of it was that he did not communicate the date to the President at that time when he made the submission, and that is the story, Chairperson.
Yes.
I want to understand, Judge Mlambo, when, before 1 January 2018, Judge Makhubele indicates that she can only start in April 2018. When she indicated this date of 2018, had you already written to the President in regards to the starting dates for the judges?
I think if you recall in my evidence earlier in the day, I said when I sent the directive of the 19th of October, I had already communicated with the ministry the date of appointment of the judges being 1 January, all of them. So I don't know what you're asking me to comment on, but I just wanted to correct that part.
Okay. So it's a correction that by the time when you had spoken to her, you had already submitted your memo to the president?
Yes, not to the to the minister.
To the
The minister
ministry,
would have
sorry.
communicated with the president. Yes,
Okay.
and I think my basis should be understood. The only reason that Judge Makhubele had given me for wanting to start in April, and which I did not agree with and didn't approve, was that she wanted to continue with her work as Water Tribunal chairperson. And my basis has remained the same, that there's no conflict if you continue as Water Tribunal chairperson and take your appointment, because that's judicial office.
Sorry, Chair, I just want to find out if there's any questions that the council would like me to put.
Judge, should we have there are a few questions. Should I quickly discuss with the evidence leader before? Okay. I think.
Thank you, Judge Mlambo. Advocate Zungu, you got any further questions for the witness?
Yes, thank you, Chair. Just a few. Judge Mlambo, I would like to refer you to volume 15, page 10. 15, page 10.
Thank you. I've got it.
This is an email from yourself addressed to Judge Makhubele. Dated the 6th of December 2017. And it's flowing from the email of 4th December 2017.
Yeah.
What does that email say to Judge Makhubele?
It says, "Hello, Nana. Thanks for your email. The delay has been your undoing, unfortunately. The President has already done the appointment with effect from 1 January 2018. I'm waiting for the appointment letters and certificates. We can meet week after next."
And did you meet week after next?
No.
Okay. Were there any arrangements made by Judge Makhubele to meet the week after next
We didn't
with
meet.
yourself?
We didn't meet. That's why I had to call her to say, why has she not come to take the oath in January?
Okay. Can you refer to same bundle on page 20, same bundle, page 22. This letter we've already referred to. There's just certain questions that are arising from that letter. This is the letter that you addressed to Advocate Masuta, who was at the time the Minister of Justice and Constitutional Development.
Yes.
We've already referred to this letter, but there's just few questions I've been requested to ask. Paragraph 5, with specific reference to page 23, the next page. Paragraph 5, you said in your earlier on that in the same letter you had requested that 2 advocates be appointed and to replace Judge Makhubele during the term. Can you indicate to us whether those advocates were in fact appointed?
Yes, they were appointed.
Okay. Then on the next page, which is page 24, it's a letter by Unite Behind that is addressed to yourself, and that letter is dated 26th of January 2018. Did you receive this correspondence?
Yes, I did. I responded to it too.
And you responded to it. And then if you go on to page 32 of the same bundle, is that the response that you addressed to Unite Behind?
Yes.
Okay. In regards to paragraph 5 of that correspondence, which is on page 33,
Yes.
it's noted, I further confirm that I forwarded a letter to Madam Justice Makhubele for her noting and comments, if any.
Yes.
Few questions in regards to that correspondence. Firstly, why did you refer to her as Madam Justice Makhubele?
But she was appointed a judge already, isn't it?
Yes. Okay. And did you indicated that you forwarded your letter to Madam Justice Makhubele for her noting and comments, if any.
Yeah.
Did you get a response from her?
I can't say offhand if she did respond, because there's a lot of correspondence that happened, but I can't recall if she responded. I think at that time she was also dealing with Unite Behind in her own right. I think probably she would have received correspondence, I don't know. But I don't recall if she responded to my referral of the letter.
Thank you, Chairperson. At this stage, I have no further questions.
Thank you, Chair. Chair, I'm going to be all over, but I'll try my best to synthesize the themes that I'd like to explore with Judge President Lumber. JP, you and I are friends.
That's true. We're
for
friends.
a long time.
Yes.
And the questions I'm going to pose to you are in that spirit of friendship, accepting that I have ethical obligations to Judge Makhubele
Yes.
I represent today. And I hope that we remain friends after today.
I hope so. I don't think anything will change that.
Can I start where our learned friend for the pro forma prosecutor ended up? He asked you to look at volume 15, and he did so in the context of the letter which was written to you by the complainant. And that letter starts at volume 15, page 24. The letter of 26 January 2018. And in time and place, the letter comes after the 1st of January 2018. So in that context, may I ask you to look at page 25, paragraph 3, where the complainant begins to raise its issues about Judge Makhubele. And then they go over to page 26 to indicate what their interests are concerning Judge Makhubele's involvement in PRASA. Then if you go to page 27, they deal with matters of concern around state capture. Do you see that from paragraph 10?
Yes, I've got it.
And I take it that you had read what the complainants were saying before you responded to this letter.
Yes.
And then in paragraph 12, they deal with matters relating to PRASA and the Minister of Transport. And then at page 28, paragraph 15, they talk about the appointment of the CEO relating to PRASA and some other issues they have regarding the report of the public protector, which investigated the affairs of PRASA. And so it goes on about a litany of the complaints they bring to your attention. But the sum total of those complaints or concerns they have raised with you directly is captured in paragraph 19 on page 30. And I'm going to ask you to read that along with me, because I'd like to ask the tribunal at the end of the evidence to draw some conclusions relating to that paragraph. So let's read it together. As chairperson of the interim PRASA Board of Control, Justice Makhubele is carrying out functions in the executive domain and is accountable to the Minister of Transport, Parliament, the Minister of Finance, and the Auditor General. As stated before, this letter is not a complaint, but an attempt to alert your office and Justice Makhubele to our concerns and to avert unnecessary tension or conflict. First proposition I'd like to put to you is that you were aware when this letter was addressed to you that regardless of the matters that the complainant raised in this letter, they were not lodging a complaint with you about the position Justice Makhubele held at the time at PRASA, correct?
Correct?
And thereafter, in your correspondence with Justice Makhubele, you did not take the contents of this letter as representing a complaint against him, correct?
Correct.
In your correspondence with the Minister of Justice that flowed after you had decided to engage the ministry on the change of date of commencement of office, you never regarded the complaints or concerns raised by the complainant in this letter as some form of a formal complaint against him.
Yes.
Yes. And can I ask you then to look at your response to that letter at page 32. And in paragraph 32, you do inform the complainant that you have requested that the appointment of Judge Makhubele be with effect from 1 April 2018, correct?
Yes.
We will come back to precisely what is the purpose and import of the date of commencement of office upon appointment as a judge. And you say that that request of Madam Justice Makhubele, the request for the taking effect of office from 1 April 2018 was a request coming from Justice Makhubele.
Yes.
And again, I would like to later on take you through correspondence, simply to explore this fact with you, that Justice Makhubele made no secret about communicating her request to you.
Yes.
It was an open request to you. She did not conceal anything relating to her desire to start from 1 April 2018, correct?
She concealed the PRASA appointment.
We will get to the PRASA issue because it seems to me that you suggested that it is something that had worried you.
Yes.
I'll come back to it later on when we talk about the correspondence you directed to the Minister of Justice. But your suggestion is that she concealed that fact
Yes.
from you. Okay. And once you learned about it, did you regard it as something that affected her suitability to occupy the office of a judge?
I voiced my displeasure
No, I
during the
understand.
meeting. we had
Understand.
with her. Yes.
The point is, did you regard it as something that affected her suitability to occupy the office of a judge?
Yes. I would not have voiced my displeasure had I not held that view, that she had rendered herself unsuitable by joining a litigant who was featuring in the division.
Can I interrupt myself here and take you to a letter that you wrote to the Ministry of Justice? And that is on page 22 of the same volume.
22.
Yes. This is a letter that you wrote on the 22nd of January 2018.
Correct.
And it is the letter that you write to request then Minister Masuta, who was the Minister of Justice and Constitutional Development, as then known, that her date of commencement of office be deferred.
Yes.
And by that time, you had known that she was the acting chairperson of the interim board of PRASA.
Yes.
And you mention the reason why you requested the deferral. In paragraph 2, you say to the minister, Madam Justice T.A.N. Makhubele approached me after I had notified the ministry of the appointment date of all newly appointed judges of this division. She will require a few more months to fulfill all her tasks as the chair of the Water Tribunal and has kindly requested that her date of appointment be amended to commence on 1 April 2018 instead of 1 January 2018. Correct?
Yes.
And you don't mention in that paragraph or elsewhere in the letter whatever concern you may have had about her involvement in PRASA.
No, I didn't.
And I take it that there must be a reason why you did not disclose that in the letter.
Well, I think, as I said earlier, her official reason to me for wanting to start in April was mainly her waterbed chairpersonship. The PRASA issue came out because we extracted it out of her. It's something clearly that told us she didn't want to talk about.
No, I understand, but the point is, at this stage, when you write to the minister, you are
Yes.
aware of her involvement in PRASA.
Yes, yes.
And the point really is that you don't tell that to the minister as one of the reasons you requested her deferral of commencement of office.
That's correct.
And there has to be a reason why you did not tell the minister of that matter, which, in your view today, was of concern to you.
Yes.
And I respectfully suggest that the reason why you did not disclose that fact to the minister is that you did not consider it as a matter that affected her suitability to be and remain in office as a judge. And I'll suggest to you why that is so obvious. Because what you request is for her to remain in office but start later on. So by that logic alone, you still regard her as a judge suitable to serve in office, but only from 1 April 2018.
Yes. So, do you want a response? Or?
Maybe the tribunal will be interested in the response, but yeah.
I think I've tried to illustrate that it was us who extracted the PRASA issue out of Judge Makhubele. She didn't want to place it on the table as her reason for not wanting to start in January. Her official reason was her Water Board Tribunal chairpersonship, and that's what I put there. Yes, I had concerns. That's why I expressed them to her in that meeting, to say it's unbecoming of her to join an entity that is featuring in the division in litigation regarding alleged corrupt tendencies, and then come back to the division as a judge.
Judge Mlambo, we'll get to the date on when she took office.
Yes.
But for now, and I don't want to repeat myself, all I'm saying to you is that a matter of momentous concern to you was not disclosed to the minister in this
Yes.
letter. Can I get back to where I was before I interrupted myself?
Yes.
And I was at page 33. In paragraph 4, you, in response, communicate the following further matters to unite behind. The first is that Judge Makhubele had not taken oath of office as at 29 January 2018, correct?
Yes.
And I suppose that is what we casually call the oath of office by judges before they commence their duties as judges in Schedule 2 of the Constitution. And there is a reason why judges are required to take an oath of office
Yes.
before they serve as judges. Before I suggest my reasons to you, would you be able to offer your own understanding of what the reasons are for judges to take oath of office before they commence with their judicial functions?
In a nutshell, my reasons are, in that oath, judges are swearing fealty to the Constitution, that they will be not swayed by anything, but they will just be answerable and accountable to the Constitution in carrying out their judicial functions.
Yes. Would it be fair to suggest to you that that oath of office, it's a clear and manifest indicator that a judge would not suffer from conflict of interest in fulfilling his or her duties?
Yes.
Thank you for that. And then you go on and you say, she has not been paid any salary as a judge.
Yes.
And I don't know what further evidence we will have as the proceedings unfold. But my instructions are Judge Makhubele never claimed any salary before she took office from the 1st of June 2018. Would that be consistent with your understanding?
Yes, she never claimed any salary because she didn't sign the forms that would have authorized the salaries unit to deposit money into her account.
Yes. And there's a reason why she did not claim salary until she took office from 1 June 2018. It is because of the fact that she did not regard herself as a judge. Do you want to comment on that?
That's her view, but a small correction in that narrative, Advocate Malika. At the end of March, she was ready, after her discussion with Advocate Kosana, to submit forms to start getting a salary.
Indeed.
Yes.
And as we will look at the correspondence, should it become necessary for us to go there.
Yes.
At that point in time, she had communicated to you that she had resigned all her positions in the private sector,
Yes.
and that she was willing to take office. She was ready to take office at that point in time, correct?
Yes.
And your response was, look, you're waiting for the president,
Yes.
and you did not want her to take office without the president confirming
Yes.
the date of deferral. The consequence of that approach you took is that without confirmation by the president, you would not allow her to take office and serve as a judge.
Yes.
And therefore, the date of confirmation of deferral is a vital step for a judge to start with his or her work as a judge.
I don't agree.
If you don't agree, then when she came to you and you regarded her as a judge, why did you not say, I regard you as a judge, come and commence, now that you have cleared your other officers from the private sector?
Simply put, the president put a date. She didn't come on that date. It was not open to me and her to come with our own date, especially after she had requested me to ask for that date to be deferred, right? had the president confirmed that she can start on 1 April, when she approached me, it would have happened.
And that's the point, Justice Mlambo, that the date of commencement of office is fixed by the president,
Yes,
not a judge president of any division,
yes.
correct?
Yes.
Whilst I'm at this issue, may I ask you to go to page 67?
Yeah. You don't
Of the
want
same volume.
any of my comments about why I responded this way to Unite Behind?
Well, I'm not here to muzzle you. You can volunteer them as you wish. I don't want to be accused of tailoring your assistance to the commission, but
Yeah.
feel free to tell the tribunal why you responded this way to the letter of the complainant. And I emphasize it's a letter, it's not a complaint.
Yes, it's a letter, and thanks for that. As you took me through that letter from the complainant, it goes deep into what their concerns are about what's happening,
Yes,
what Judge Makhubele is doing.
yes,
I did not want to engage with any of those things
yes,
based on what I knew, what I had done.
yes.
That's why I simply said, I'll simply say to them, she's asked for a date to be deferred, and I've asked the powers that be to defer that date. And because I think the other unmentioned theme of their letter was that she was doing the PRASA work, but also doing judicial work.
Yes.
So I wanted to say to them, she's doing no judicial work. She didn't take the oath of office, hence she can't do any judicial work, and she's getting no salary. That's why I responded this way. You'll see this letter does not engage in any way with any of the issues they're raising.
Indeed, indeed. And quite correctly, you responded to all that they were saying with regard to your position as the judge president.
Yes.
Yes. Now, I had asked you to go to page 67, but Mr. Salugazana has interrupted me to draw attention to page 50
Which one?
of the same bundle.
Okay, 50.
50. This is a letter, as I understand its provenance, from Mr. Sello Chilwani, then Secretary of the JSC, dated 27 of February 2018. The letter begins at page 49. I wonder whether you have had an opportunity to read this letter before you came to testify today.
I don't recall reading it, no.
Right. I don't know whether Mr. Chilwane will volunteer to come here, but he says something and attributes a number of things to you at page 50, paragraph 4.
Yes.
And I'd like us to go through some of the things he says about you and see where you can help the tribunal. And he starts off by saying, and I quote, "We have been informed by Judge President Mlambo that Judge Makhubele has not sat as a judge in the Gauteng Division of the High Court whilst serving as chairperson of the Interim Board of Control of the Passenger Rail Service of South Africa." In your recollection, did you communicate that fact to Mr. Chilwane in his capacity as the Secretary of the JSC?
I think I did, yeah.
And then he goes on to say the following, and I quote, "She has indicated that she will only assume her judicial duties with effect from 1 April 2018. I take it that Mr. Chulano would have obtained that fact from you.
From me or my office?
Indeed. And then he goes on to say her name in the unopposed roll in the Gauteng division of the High Court was an error that was committed by the roll call registrar. I suppose, yet again, Mr. Chulano would have obtained that from you.
Yes, because the roll call registrar used an all roster, which reflected Judge Makhubele's name, because by February, the roster had changed. Her name was no longer there.
Indeed. And therefore, that was a mistake on the part of the roll call register.
Yes,
And you took that mistake seriously.
Yes.
Because the concluding part of that paragraph records the following. Yet again, I quote, Judge President Mlambo has reprimanded him accordingly for this error.
yes,
I take it that you did that.
yes.
Yes.
I spoke to the chief registrar, their boss.
Yes. Right. Should I go ahead? All right. And then paragraph 5 says the following. As things stand, Judge Makhubele has not commenced with the judicial functions, nor has he taken the solemn oath or affirmation as required by Section 1748 of the Constitution, read with Schedule 2.
Yes,
I take it that what Mr. Chulwani was saying at that point in time in paragraph 5 was correct as a matter of fact and was also correct as a matter of law.
as a matter of fact, yes. As a matter of law, I don't know what your take of it is, because I think me and you disagree.
All right. Let me leave that. The
Yeah.
judge, the job of the tribunal is to investigate the facts and
Yes.
not the law.
Yes.
I think I've done it. Can I move on? I have explored the concerns of Mr. Salgazana on page 50 onwards. I had asked you to go to page 6, 7. All I want to draw your attention to is the penultimate paragraph just below or above the signature date. You will see that the date when this minute was signed was the 22nd of May, 2018. And there the President says the following as a manifest of his official act. Now, therefore, I hereby amend the date of appointment of Madam Justice Makhubele to be 1 June 2018, correct?
That's what it says, amend, yes.
Yes. And what surprises me is Judge Makhubele had requested, and you had motivated for the 1st of April to be the date of assumption of duty. And yet the President decided to choose a totally different date. Did you ask the Minister of Justice why they chose a date different to the one that you had requested?
No, I didn't ask.
Yes.
I could think, I could speculate as to the reasons why that date was there, because I know that towards the end of March, that opinion that the ministry had sought had not seen the light of day. I had not seen it in particular. So and I think what the minister had said was, they want this opinion in order to advise the president accordingly.
Yes.
I would suspect the delay would have been on their side, hence they didn't meet April. But that's me speculating.
All right. Thank you for that. The president was well within his right to determine a different date of commencement
Yes,
than the one that you had requested, correct?
yes,
There's nothing unlawful about that.
no.
If you go to page 68,
So you don't want me to comment about what I understand this?
again, I'm sorry if I move faster than what you want to tell the tribunal.
I don't think it's for Mr. Advocate Malika to deny us what we should be hearing.
Indeed.
We want to hear the truth. We must make findings. If you feel something will help us, JP Mulambo, tell us now. Don't let him control you.
Yes.
It's for us.
Justice Mshida, I'm very grateful for that observation because I don't want to be seen to be curtailing the evidence of Judge.
I understand.
Yes.
Very glad. Dependent
Yes.
on him being allowed by you to comment on our issues,
Yes.
which we should actually be doing.
Thank you for that, Judge Moshidi.
Could I hear what you wanted to say, please?
I think as you were questioning me, I made a small comment to say, this note or this presidential minute says amend. If you listen to my evidence earlier, I hold the view that in line with the three-stage process of the appointment of judges, Judge Makhubele was appointed the judge by the president in that minute dated sometime in May. That's the Appointment Act. And in line with that appointment, the president determined when she could commence her judicial functions. And he said 1 January. My interpretation of this minute when he says amend is, I'm not fiddling with my appointment of Judge Makhubele. She remained a judge throughout. But I'm saying she can start in line with the request by the judge present to defer her start date. She can start on 1 June 2018.
Judge Malamula, I'd like to test that. I know that that's a view you hold.
Yes.
But you seem to be speaking for the president. And the president has told us what he wanted to say in official documents.
Yes.
And I'd like to test what you said. Go to page 68. Again, this is the president speaking to you and all other concerned. And you see that it's an appointment certificate, correct?
Yes.
And it is addressed to, again, I quote, not to be misunderstood, Advocate Tenswalo Ana Nana Makhubele SC.
Yes.
The president is addressing this candidate not as a judge, but as an advocate, senior one at that point in time, correct?
Yes.
And he says, you advocate, under section 174, subsection 6 of the Constitution of the Republic of South Africa, 96, I here appoint you as a judge. You see that?
Yes. Yes.
Of the Gauteng Division of the High Court, correct?
Yes.
With effect from 1 June 2018.
Yes.
Now, this is what the president is communicating to Judge Makhubele and to the world,
Yes.
that I regard you as an advocate at that point in time, under section 746, and we'll look at it. I now appoint you as a judge, correct?
Yes. Can I vouch my understanding for what happened, unless you have other questions you want to ask?
No, go ahead, go ahead.
This certificate is the same as the certificate that says she starts 1 January 2018. It's the same. The only thing that's changed is the date. And what explains that date is the minute that says amend. In line with the view I hold, she was appointed in November as a judge and remained a judge. And when she asked for her date to be deferred, she didn't start, but she remained a judge.
No, I understand your view,
Yes.
but I've explored the view of the President.
Yes.
Can you go to page 69? 69 of the same volume. We have explored the view of the President.
Yes.
Let's explore the view of another bureaucrat, and that is the Minister,
Yes.
on page 69. It is a letter dated 24 May 2018. 24 May 2018. It follows hot on the heels of the President's letter or certificate of 22 May 2018. And I'd like to explore aspects of this letter with you to reflect what the views of the Minister of Justice was at that point in time. Again, it's a letter addressed to Advocate T.A.N. Makhubele, SC. Do you see that?
Yes.
And the Minister addresses her as Dear Advocate Makhubele. Do you see that?
Yes.
And the heading is Appointment as a Judge. And he says, it gives me great pleasure to inform you that in terms of Section 174, subsection 6 of the Constitution of the Republic of South Africa, 1996, you have been appointed by the President as a judge of the Gauteng Division of the High Court with effect from 1 June 2018, correct?
Yes.
And again, the Minister not only addresses the relevant candidate as an advocate, but tells her when she will commence office, correct?
Yes.
And this is a date consistent with the one of the President's certificate we have just looked at.
Yes.
And both those dates confirmed by both the President and the Minister
Yes.
are different from the one that you had motivated for,
Yes.
correct?
Yes.
In that context, I would like to ask you to look at page 70. And this is the oath of office which had been taken by Judge Makhubele. My reading of it is that she took the oath of office on the 8th of June, 2018, correct?
Yes. That's the date, yeah.
Yes. We have looked at this burden of documentation before the tribunal with all its repetitive manifestation and have not come across any other oath of office taken by Judge Makhubele other than the one that we see on page 70. If there was any other oath of office, you would have known about it, correct?
Yes.
So it will be fair for the tribunal to proceed on the premise that the only oath of office Judge Makhubele took is the one on page 17.
Yes.
Thank you. Now, I'd like to, before we complete our examination today, reflect on some statutory and constitutional provisions that were conversed with you by our learned colleague for the pro forma prosecutor. And I take it that you have that booklet for judicially regulatory instruments before you.
I've
Yes.
got it.
Thank you. She took you to page 125 and asked you to look at the oath of office. And she did so by asking you to look at section 1741 on page 85 of the booklet. But I'd like to look at page 86.
86.
Yes. Subsection 6 of section 174 of the Constitution. And it says, the president must appoint the judges of all other courts on the advice of the Judicial Service Commission. Correct?
Yes.
My understanding of the full amplitude of these presidential powers is that it is the president and no one else who appoints judges.
Yes.
It is not even the JSC which appoints judges.
Yes.
At best, the JSC recommends to the president.
Yes.
And where appropriate, the president is free not to act on that recommendation.
Yes.
I think the well-known example, Chair, is the recent recommendation for the highest judicial office. You would recall that the JSC recommended one candidate and the president chose a totally different candidate. Yes. 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 Now the question is this, that it is the right of the president to determine when a judge should take office. At best, you as the JP can request a date,
Yes.
and the president has a right to determine a totally different date if he or she chooses.
It is his prerogative
Indeed.
to appoint a judge and determine
Yes.
when that judge starts working.
Indeed. I'm grateful for that. Now, you were taken to part of the code and you were asked to comment on two clauses of the code. The one is Article 2.2, and I'd like to clear something because there ought not to be some misunderstanding going forward. You will remember Article 2.2 is at 303, page 303 of the booklet.
Yes.
And you were asked to comment about what is the meaning of a judge not on active service.
Yeah.
My understanding of your evidence is that that phrase refers to a judge who is on retirement.
Well, I gave the retirement example
Okay.
because that's a clear example of someone who's not on active service.
Yes.
There are other judges, the other instances where a judge properly appointed is not on active service. Either is sick or for some other reason can't perform judicial functions.
Yes. Are there any other examples that you would want us to work with beyond those you have just mentioned?
Well, one clear example is the one we're busy with here.
So are you saying that Judge Makhubele was someone who would fit within the remit of Article 2.2?
After her appointment, permanent appointment, she was not on active service until June.
Okay, I don't want to repeat myself, but you say she would fit within
Yes.
the remit of Article 2. Okay, understand your evidence. Let's go to the next part of the code, which is Article 12.2 on page 311. And you would recall that Justice Chapi sought your understanding of when this code or part of the code kicks in. You remember that?
Yes.
And his reading of the code, which with respect is our reading too, is that that clause kicks in upon permanent appointment of a judge.
That is, you are free to do whatever you want to do until the date when your permanent appointment takes effect. Then you start getting out of everything. Is that your understanding? Because
It's
I don't
my-
have a different. I don't have
Yeah,
I
and-
don't have that understanding.
And I'll tell you why it's an understanding that we will contend for. And in
Yes.
fairness, I'd like to give you an opportunity so that when we argue in your absence,
Yes.
we should not be regarded as having been unfair to you.
Yes.
The fact that the Judicial Service Commission may have recommended you for appointment does not mean that your appointment automatically will come into effect.
Yes.
There is always a possibility that you might not be appointed by the President, for whatever reason.
Well, I'm quiet because I'm trying to think of any situations where the president has never done that, other than the example you've just cited. I'm aware of only one example, I think, in the history of this country, where the president didn't appoint.
Yes. But it's always possible that the President might not appoint,
Yes.
and that's why the code contemplates
Yes.
that it imposes these ethical obligations upon permanent appointment by the President.
Yes.
Yes. And it makes sense, Justice Mlambo, when you think about it. If you resign all your positions that you hold before the President gives you the certificate of appointment, and it happens that you're not appointed, you would have lost all the benefits flowing from the previous offices you held.
Yes.
Yes,
You would have lost all those things,
indeed.
but at some stage you get indication that it's happening with effect from another date in the future.
Yes. Yes. Justice Mlambo, within the time available today, I'd like to get to the directive that you issued yeah. The heading, the one that says the directive, the registrar's note. Yeah. Can I ask you to go to, again, volume 15, page 12.
Yes, I'm there.
15. Are you there?
Yes, I'm there. Page 12, you said.
Indeed. The date of this directive is 19 October 2017, correct?
Yes.
And the subject matter of it is directive for newly appointed judges. You see
Yes.
that? But in truth and in fact, there were no newly appointed judges at this point in time.
Yes.
So it is fair for the tribunal to approach this part of our evidence on the basis that the directive misdescribed the true status of the addressees.
Yes. If you want to score that point, you can. These were recommended candidates for
Indeed.
permanent appointment.
Indeed.
Yes.
And it's a point of significance because if you look at the letter that was addressed to you by Unite Behind, no, the other one. I would like to ask you to go to page 37.
37.
Yes. It was addressed to the Chief Justice, but you were copied in this letter. The real point I'd like to make is on page 37, paragraph 19. Page 37, paragraph 5. Paragraph 5. In that paragraph, Unite Behind records that on 19 October 2017, then Advocate Makhubele was appointed by Mr. Joe Maswanganyi as the Minister of Transport, as the chairperson of the Interim Board of PRASA. You see that?
Yes.
So really the point I'd like to make at this stage is that on that date
Yes.
of the 19th of October 2017, when Judge Makhubele was appointed by Minister Maswanganyi, she was not a judge at all
Yes.
of your division.
Yes.
At that time, there was nothing which precluded her from taking office because she was not a judge at that point in time.
I don't agree. She'd been recommended for permanent judicial appointment.
Is there anything that we can look at in the Constitution, in the JSC Act, which says that when you are recommended as a judge, you are precluded from doing anything?
Well, when you use the word precluded from doing anything, you're taking it too far. She's taking a new appointment that goes contra to a standing recommendation.
But Justice Mulambo, you and I know that there would be candidates who have been recommended for judicial office who still appear before you in court.
Yes?
And there's nothing wrong in them appearing before you in
Yes.
court.
Yes. There I agree with you.
can I ask you to go to page 6 of the same volume? Justice Mashidi is the same volume, volume 15. Volume 15, page 6. Justice Japi, I've been told that when you want to read the emails, probably you start from the bottom and you go up. So on this page 6, I'd like to start from the bottom email. Judge Mlambi, you'll see that the trail of email starts on the 20th of October 2017
Yeah.
from Tintswalo Makhubele. I think that's the caption description. Do you see that? And she addresses you as JP, correct?
Dear JP, yes.
Yes. And then she says, thank you for your support and recommendation. I'm glad to accept the placement in Pretoria. I would like to have further discussions with you regarding the starting date of my appointment.
Yes.
Yes. My apologies. Let me read it out again, Judge Mlambo. In the email, Tintswalo Makhubele says, thank you for your support and recommendation. I'm glad to accept placement in Pretoria. I would like to have further discussions with you regard to the starting date of my appointment. Are we compelled to purchase new vehicles, or is it allowed to just claim allowance? And on the next page it says, I look forward to meeting you soon to discuss the matter in one. Do you see that?
Yes.
And you respond to her on the 23rd of October 2017, and your response is captured at the top part of the page. And you say, thanks for your response. You are not compelled to procure a vehicle, and yes, you can continue using your vehicle and claim S&T. I suggest that you indicate what your view is regarding the starting date via email, as I'm hectic this week. I hope you find this in order. I see that you address her as Nana.
Yes.
When she addresses you as JP.
Yes.
And was there any reason why you would address her in that way?
I've always addressed her that way.
Okay.
If I knew what a clan name was, I would address her using it.
All right. On page 8 of the same volume, she responds to your email of the 23rd of October 2017. And she says, Dear Judge President Mlambo, I apologize for taking time to respond to your email below. I had to do much reflection on the matter, taking into account all the positions that I am currently occupying. After much reflection and considering every aspect of the challenges, I think that it would be in the best interest of the bench that I start in April 2018. I trust that this will be acceptable to you. I am hopeful for a meeting with you to explain the challenges. I take it that you received this email?
Oh, yes, I did. And I think we should also mention that she's responding to my email of the 23rd of October.
Yes.
And her response is on the 4th of December.
Yes, but she does tell you in that email that she apologizes for taking time to respond.
Yes.
And I take it that you accepted her apology.
I did,
Yes.
but I think my follow-up email explains why I'm mentioning the 4th of December.
Yes. And then in that email, she does tell you that, look, she is requesting a change in the starting date.
Yeah.
Yes. And she is still requesting to meet with you in person. And you will see that in that email, she talks not about one position. She talks about all the positions she was occupying at that
Yes.
point in time.
Yes.
And then I ask you to go to page 9. Page 9. And you then respond to Judge Makhubele's email of the 4th of December. And again, you say, hello, Nana. Thanks for your email. The delay has been your own undoing, unfortunately. The President has already done the appointment with effect from 1 January 2018. I am waiting for the appointment letters and certificates. We can meet after next week. Now, the question which I ask you is, flowing from what the pro forma prosecutor asked you, was there any meeting that took place between you and Judge Makhubele after your email of the 6th of December 2017?
I can't recall if there was a meeting.
Judge Makhubele has instructed me to indicate
Yeah.
that you met with her at your office after this email. Would that be something that is consistent with your recollection?
As I say, I can't recall if there was a meeting. If she says there was a meeting, I won't dispute it.
Yes. I think she will tell the tribunal that there was a meeting between you and her after the 6th of December 2018. 2017, my apologies. 2017, thank you. Chair, I see that it is 4 o'clock. Yes, there are matters that I'd like to converse with Judge Makhubele.
I'll be here at 10, Chairperson.
No, from my side, I would like to adjourn and discuss with our colleague on the handling of documentation. Thank you, Chair.
Chair, okay, I'm requesting, I don't know, with the indulgence of the tribunal and the colleagues, that maybe, tomorrow is Wednesday, it's only Thursday. I think it's only 2 days, and then Friday. Maybe if we can start a little bit earlier, so that when we are driving back down to KZN, to give us an opportunity to leave early, maybe on Friday. But I mean, then,
Friday, we will deal with Friday when we get there. But tomorrow, we will start at 10 o'clock.